Good morning, everyone. Dylan Fuge, Chair of the Oil Conservation Commission, calling to order day 2 of our November 2023 Oil Conservation Commission hearing that was previously noticed with our original notice. I'm going to run through a quick roll call. Commissioner Mpoma. Commissioner Bloom.
Here.
Let the record reflect that we have a quorum and the full commission's present. And we are resuming case number. What's the case number?
23686 and 23687.
We are resuming case numbers 23686 and 23687's application of Chevron to construct 2 saltwater disposal wells in the Delaware Mountain Group. Where we left off yesterday was OCD was going to begin the Oil Conservation was going to begin its affirmative testimony, but I understand from counsel for the party there may be some administrative matters to discuss first, so I will turn it over to Ms. Bennett for the record.
Thank you very much. Yesterday, we at the end of the day, we closed our case, but there were 2 sets of exhibits that I wanted to admit before our case is officially closed. And those 2 sets of exhibits are fairly ministerial. The first set of exhibits is tab E, which is the witness resumes. And we walked through the witnesses' qualifications on direct, and all the witnesses were accepted as their credentials were accepted as a matter of record. So I would ask that tab E, the witness resumes, be admitted to the record.
Any objection?
None.
Consider admitted.
Thank you. And the final exhibit packet or tab is tab F, which are the hearing notices showing that notice of these hearings or these cases, as you all may know, were originally set for hearing before the Oil Conservation Division, and then they were continued to the commission. And so the tab F shows that notice of the hearings were timely mailed and that publication was timely done. And so I would ask the admission, and there's also a self-affirmed declaration by myself that goes through those facts as well. So I would ask the admission of tab F, the hearing notices.
Any objection?
No.
Exhibits are admitted.
Thank you. And then I have one more item I'd like to share. Yesterday during the hearing, we were asked to submit revised exhibits, 2 revised exhibits. This exhibit is revised to only show the change in the date. Yeah, I apologize that it's not ideal the way I'm looking at it right now. There we go. So we changed the date. That's the only revision to this exhibit. And then on this exhibit, which is marked as page 150 of 267, we revised the label as requested by Commissioner Mpoma. And so with that, I would ask that these 2 exhibits be admitted into the record to replace the prior exhibits.
Any objection?
No objection.
Exhibits are admitted.
Thank you. And so just a final request that all of the exhibits that we submitted in tabs A, B, C, D, E, and F, and these final 2 exhibits be admitted into the record for these 2 cases.
Any objection?
None.
They're admitted.
Thank you very much.
Mr. Tremaine?
Thank you, Mr. Chair. The Oil Conservation Division would call our first witness, Mr. Brandon Powell. May I have permission to take a sharing screen?
Yes. May I ask the court reporter to swear in the witness?
Please raise your right hand. Do you swear or affirm that the testimony you give today will be the truth, the whole truth, and nothing but the truth?
I do.
All right. The witness may be seated and we will begin.
Good morning. Could you please state your name for the record? Brandon Powell. And what is your current position with the OCD, Mr. Powell?
Deputy Director for the OCD, overseeing engineering and environment.
And could you briefly describe your duties in your current role as Deputy Director?
So I oversee the engineering
right. All right, just confirming, court reporter, can you acknowledge you can hear us again?
I can hear. The last thing I heard was Mr. Tremaine asking for the witness's name.
Brandon Powell.
So we're going back to introduction.
Did you, were you able to, do you have the swearing in of Mr. Powell, or do we need to go? Or
I
you-
have this. I have the swearing in of Mr. Powell. If we could resume from there, please.
Apologies, Mr. Powell, you may begin your testimony.
Okay, Mr. Powell, what is your current position with the Oil Conservation Division?
My current position is the deputy director overseeing environmental and engineering.
And as the deputy director of the Oil Conservation Division, can you briefly describe your duties in that role?
My current role overseeing the engineering bureau, I oversee the UIC group, the administrative permitting group, and the inspection groups, and then also the engineering bureau chief.
Could you also please provide for the commission a summary of your education and experience outside the deputy director role?
As it relates to this case, I've been with the OCD since 2006, so just a little over 17 years. I have overseen well, downhole engineering, well work, those kind of things since 2011. And then since 2020, I've directly overseen the UIC group as the engineering bureau chief, and then I was promoted to the deputy director earlier this year.
Is your education and experience summarized in what's marked as OCD exhibit number 1?
It is.
Is that the document that's on the screen right now?
It is.
And you prepared that document?
Yes, I did.
I would move admission of OCD exhibit number 1.
Objection?
No.
Admitted.
All right, Mr. Powell, I would like to move into the substantive portion of your testimony and direct your attention to OCD exhibit number 4. Did you prepare this exhibit?
Yes, I did.
And could you briefly summarize?
Mr. Tremaine, are you intending to have Mr. Powell recognized as a technical expert or otherwise?
No, we were
Or just
presenting
a fact
Powell
witness.
as a fact witness. He's presenting on history and summary. We have 2 technical experts coming shortly.
Just wanted to clarify. Thank you.
Thank you. Mr. Powell, could you please briefly describe the exhibit number 4 for the commission?
So exhibit number 4, and I'll go through it in its entirety. It's intended to be an overview of the DMG injection as it relates to production in the areas in the southeast part of New Mexico. It's a high-level overview of production information and practices. It's a culmination of information both from OCD information from the Bureau of Geology, and then various papers.
Thank you. So, Mr. Powell, the first page here on exhibit number 4, which is up on the screen, is just the introductory slide. If I could point you to slide number 2, could you please summarize the slide, the information that's contained on slide 2?
So slide 2 goes through an overview geology-wise of where the DMG is located and the production history of the DMG through the different decades, how the different decades produced the different zones. Also, it summarizes that in 2007, there were 250 productive pools in the DMG. And through 2010, the cumulative production is shown at the bottom of the slide for the DMG as a whole.
Are there specific areas on the slide that you would highlight or point out to the commission as significant in reviewing this case?
So as it relates to this case, when you look at the formations on the right-hand side, you'll see where the Bell and the Cherry Canyon that Chevron's proposing were primarily produced from our drilling what happened between the 50s and the 80s. The Brushy Canyon, which they're planning on doing a defit in but not producing, is a formation that has had wells drilled between the 90s and currently.
Great. And Mr. Powell, I'm going to move on to slide number 3. Could you please describe the commission information that's contained on slide number 3?
So slide number 3 just goes over historical practices as it relates to the DMG. Most of these practices started or happened in the 2010s. It starts off with pre-2010, most DMG disposals in the DMG were smaller, centrally located field-based wells. The volumes were significantly smaller than what we're seeing being utilized today. The next 2 bullets are just summaries of different times, significant times in the DMG injection in the area. And then slide number 4 details the Bobco cases that were significant as far as limiting DMG injection in the area, because it showed where wells had crossed over to production and inhibited that production. Part of at least one of those wells, when I put this slide together, were still not recovered. As a result of growing interest in issues in the DMG disposal, NMOGA provided an exclusionary map for restricting DMG injection to protect relative rights and reduce drilling complications in the area. And I believe that's the same one that Chevron's already shown, but I'll get to that later in my slides as well.
In terms of the history and OCD practices that are outlined on this slide, how does, from the deputy director's position and viewpoint, how does this history inform how you review applications for injection in this area? Essentially, what are OCD's overarching concerns?
So OCD's overarching concerns in DMG injection as a whole is centered around relative rights, ensuring that they're protected, that we're not sacrificing relative rights for injection intervals for future use, because relative rights are one of our primary drivers for protection. So it's just to make sure that those are protected.
Moving on to, actually, if I can stay on, strike that. Moving on to slide number 4, Mr. Powell, can you please describe for the commission the information that's contained on slide number 4?
So the map on the left is the NMOGA identified protectable areas. These are the areas that Chevron has already addressed in their testimony that relate to the Avalon and potential cross flow and production there. The slide on the right was a map that was put together by the Bureau of Geology, and it shows high potentials for production in the future. There's high, moderate, and low potentials as shown by the red, the green, and the blue lines around the map to show future potentials in that area as they were determined in 2007.
And for purposes of clarification, is it fair to say that the areas depicted on this map are the same as the areas that were described in Chevron's testimony, or stated otherwise? There is not a factual dispute about the areas defined in the slide.
There's not a dispute. I don't believe Chevron showed the map on the right, but they did show the map on the left.
Moving on to slide number 5. Mr. Powell, can you please briefly describe the information that's contained on this slide?
So this is a rough overlay that combines the NMOGA map with the potential production map, and then inserts the 2 Chevron wells in the areas. It shows that both our wells being proposed by Chevron are outside of that high potential area that was previously identified, but both inside of the area of the NMOGA.
Great. And for clarification, how is the NMOGA map depicted on this overlay?
So the NMOGA map is in that light blue line that overlays the 3 lines of the high potential area.
So from a high level review from OCD's perspective, these wells, proposed wells, are outside of the high potential production DMG zone, but within the outwater protection zone noted or proposed by NMOGA.
That is correct. The wells are on the outer boundaries of the Avalon protection area by NMOGA, and it's outside the high potential by the Bureau of Geology. The way OCD is looking at them is OCD doesn't support the application, nor does it oppose it because of the lack of information that's in the area. That's why the OCD technical witnesses later on will go in depth as far as what we're recommending required for these wells and future wells. Because we see them as an area that we just don't have a whole lot of information. So we need to gather that information.
Given this background, the history that you outlined of both the development and SWDs in the area, and the concerns highlighted in your presentation, does OCD have any recommendations for conditions of approval, appropriate guidelines that you have the commission to approve regarding this in future applications?
So the technical witnesses will dive into the conditions that OCD is looking for, and they're better versed to talk about those conditions themselves. But yes, we see them. This area is similar to like a development well for production. It's outside of an area that's known to be used. So we're looking for conditions that will properly evaluate that area as they develop it for an SWD.
And we've heard, in the application, probably there's styling of this project as a pilot, and we've heard some testimony to that effect yesterday. From your perspective as the Deputy Director of OCD, what's the significance of a pilot designation in the context of a saltwater disposal well?
I think it's extremely necessary in this area because of the unknown circumstances in the area. To do the proper testing and gather the proper information, to see what really we're looking at out there. It's similar to an exploratory well for production, where you go out to a well, you drill it, you gather information before you drill additional wells. So it's really necessary from that perspective.
So from OCD's perspective, it sounds like the styling of this as these proposals as a pilot project and the inclusion of specific conditions of approval, data gathering, testing, monitoring. Am I understanding correctly that you believe that's both appropriate and administratively feasible for OCD?
I do, and I believe it's also necessary to gather the information to ensure relative rights are protected.
Thank you. Last question, Mr. Powell. We heard yesterday about Chevron's proposed monitoring and notification related to potential interference. Do you recall that testimony in the exhibit?
I do.
In your opinion, as Deputy Director, when and how should such notification of potential interference or actual interference occur to OCD? When should that be provided?
So what I would be looking for from the OCD side is anytime there's a potential for interference, that at least as a courtesy, the operator would be informing the OCD and other regulatory agencies of that potential. So we're aware of the situation as they work through the process.
So it sounds like you would ask that operators not wait until interference is necessarily confirmed, but if there's material information suggesting possible interference from future wells, you would want notification to occur at that point in time.
That's correct, because the reviews and the studies that go along with that can take considerable time. And if the OCD and other agencies are informed up front, they're aware of the process going through.
Mr. Chair, I'm done with our questions on direct.
Thank you, Mr. Tremaine. Ms. Bennett, do you have any questions for the witness?
Just a couple. Thank you. Thanks so much for being here and for the exhibits that y'all prepared. It's very helpful, so definitely appreciate it. I just had a couple of questions for you. If we could turn back to page 2 of exhibit 4. This page you discussed into the 2000s, there was some horizontal production in the Brushy Canyon. Have you looked at how close that horizontal production is to the proposed Severitas well or Pop Squirrel?
So I have not personally, I know Chevron, in their proposal, looked at all DMG production, within a 2-mile radius, and they didn't discover any within this area.
Thank you. And you have no reason to doubt the veracity of their review?
Not at all.
Okay. Then if you could turn to the next page, I think it was, Mr. Tremaine. It's the slide with the, one more, please.
This is, number 13.
Thank you. So, this slide shows the NEMOGA identified protectable area on the left, right?
That is correct. Yep.
And it was not intended to be an exclusion zone, was it? It was intended to be a protectable area?
That's correct. To my knowledge, it's a protectable area. I believe our technical examiners will go through it, more extensively, but yes.
Okay, but to your understanding, it was never meant to be a per se prohibition of disposal in that area.
Correct.
Do you know if Bobco was acquired by XTO? Do you know that?
Offhand, I didn't do that research.
Okay. Earlier you mentioned that OCD or the division is sort of taking a wait and see approach or not taking a position one way or the other on these two applications because of the need to gather additional testing information and to evaluate DMG disposal.
Correct.
And you were here though when Chevron went through its protocols for the data that it's going to gather and its monitoring approach.
Yes, I was.
Do you have any concerns with the data gathering that Chevron is proposing?
Between the data gathering Chevron's doing and the COAs that OCD is looking at placing, that's why we're not opposing it, because we feel it is necessary to gather that information.
So the division is agrees that additional information is necessary to be gathered in this area.
Correct.
And you see that as one of the goals of Chevron's pilot project.
Yes, I do.
Let's see. The other item I wanted to just briefly discuss with you, and this may be something to discuss more with the other division witnesses, but is about the conditions of approval. As we discussed yesterday, Chevron has some further questions or information that they'd like to discuss with the division about those conditions of approval. Is the division open to having those types of discussions with Chevron?
I think the division is always open to have those types of discussions to make sure we get the best information possible.
And I think that's all the questions I have. Thank you very much.
Thank you.
Ms. Hardy, do you have any questions for the witness?
I do not, thank you.
Dr. Impoma, do you have any questions for the witness?
Yeah, Pete. Yeah, not so much, but so on your slide number 2, you showed that there are horizontal wells
Mhm.
during the 2000s in the Brushy Canyon. So is it a concern for you when Chevron proposes to do defect in this particular formation?
I'm not, because of the area that they're looking at doing it in. There's no current production shown. My estimation, and I have not verified this, would be that those wells in the Brushy Canyon are going to be in those high productive areas that were identified in the map that I showed in the later slides.
So in your pre-hearing statement, you said NMOC does not really support or let's say against the application. But it sounds to me like based on the description, let's say going through the process, sounds like you are partially in support of the data gathering.
We are in support of the data gathering. But for the injection wells themselves in that particular area, there's not enough information for us to support the injection itself. But we do support the data gathering to get to that point.
So yesterday, Chair talked about the commission working on a milestone to be added to the conditions of approval. Is this something that NMOCD is also in support of?
Yes.
Thank you. No further questions. Mr. Bloom?
Mr. Chair, no questions. Thank you.
Mr. Powell, just one clarification, just to clarify your testimony on Chevron's flow chart that we don't need to pull up about identifying potential interference. Is it your position that you would just like sort of concurrent notification to OCD of potential interference? Do you want OCD involvement throughout the resolution, or you just want notification and then sort of not engagement, and then engagement as Chevron proposes, which is sort of when they can't work it out? What's the OCD's position?
I think when it's initially discovered, concurrent notification and then any milestones or a plan of action as it goes through. I don't see it as being official as far as within certain dates, but I think what the general plan is and and then any general milestones as they get through that process.
So is it fair to say your position is you'd like the OCD to receive notification throughout, even though it may not necessarily be a decision maker as it works through?
That is correct.
Okay. No further questions? Mr. Tremaine, do you intend to reserve Mr. Powell, or are you done with him for presentation?
Mr. Powell's pretty good.
Call your next witness.
All right, Mr. Chair, I think we can, I would call Mr. Bill Getz.
Please raise your right hand.
It's right.
Do you swear or affirm that the testimony you give today will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you, Mr. Getz. You may sit down.
Good morning, Mr. Getz. Could you please state your name for the record?
My name is Philip Getz. Last name is Goetze.
And Mr. Getz, what is your current position with Oil Conservation Division?
I am the UIC manager, underground injection control manager for the division.
Could you please briefly describe your duties as the UIC manager?
A majority of my duties to oversee both the permitting compliance as well as programmatic obligations. This includes reporting to the EPA, our grant funding, as well as both UIC wells that are issued with permits under the Oil and Gas Act as well as the Water Quality Act. I also serve as a manager overseeing personnel and doing those details.
Could you please provide for the commission a summary of your education and experience beyond the UIC manager role?
I've currently been with the division for 11 years now. I was part of the UIC group from the beginning, but I also share responsibility as a hearing examiner. I have some 300 cases, which I've issued orders on. I, prior to that, worked for a consulting firm doing assessments as well as characterization of waste, Los Alamos, Sandia, and going back even farther, several prominent national environmental firms doing underground storage tank removal, waste characterization. Also performed as a contractor oversight for EPA and consent order consent agreements. Prior to that, I was with the U.S. Bureau of Land Management in Wyoming, overseeing oil and gas operations and lease resolution. That was a job inherited from my job prior with the United States Geological Survey, which I did both coal and oil and gas identification in the state of Wyoming. That was briefly interrupted with a stint with the United States Bureau of Mines doing mapping of wilderness areas. And with that, prior to that, I was a graduate of New Mexico Tech, class of 77 with a geology degree.
Mr. Getz, is your education and experience summarized in OCD exhibit number 2, which I'm currently doing a very poor job of sharing? Is this your resume or detail?
Correct.
Okay, and you prepared this?
I did.
Okay, and at this, have you testified before the Oil Conservation Commission in the past?
Yes, in both capacity as a witness for rulemaking as well as a witness in cases before the commission.
And have you previously been tendered and accepted as an expert at this commission in the areas of petroleum engineering and underground injection?
Correct.
At this time, Mr. Chair, I would move admission of OCD exhibit number 2 and tender Mr. Getz as an expert in areas of petroleum geology and underground injection.
Any objection?
No.
The exhibit submitted and the witness is so recognized.
Mr. Getz, I'm going to move on to a series of exhibits and walk these through kind of the substance of your testimony now. If I can point you to the screen and OCD with regards to OCD exhibit number 5. Could you please, what is this exhibit?
As part of the typical presentation regarding Delaware Mountain Group, we provide to commission as well as our examiners a base document that gives the best documentation on what the Delaware Mountain Group is composed of. Literally, this is the reference for DMG, written by NANCE, Bureau of Economic Geology, University of Texas. We use it a lot, and we base a lot of our interpretations off the information that's given. It also provides a snapshot. Its figures are very representative of what type of environment we're dealing with, especially when we use this interval for injection, which is becoming more apparent that is going to be the place to go to. So with this, we provide both commissioners and our examiners the ability to see details, which I think gives you a better spatial understanding of what we're dealing with.
Right, Mr. Getz, this is a rather substantial paper, so I'm not going to ask you to go through all of it. It's available for the parties and the commission's review in detail, but I'm going to ask you now if you could highlight for the commission any specific areas of the paper that OCD focuses on in reviewing applications such as the applications in these 2 cases.
Well, I would take you to figure 8, which I believe is page 69. It gives you a sense of the complexity of what we're dealing with. Even though mapping has been very substantive in the subsurface geology, we have a lot of information. Still, the 3 formations represent very much a relationship that has been complex for us to keep within our definitions and our permit guidance. The Cherry, Bell Canyon Cherry, and the lower Brushy Canyon. Of the 3, the Brushy represents the most diverse as far as channeling and structuring and features. And of course, this represents also typically what is now the last prominent play within the 3 formations. The shallower, the upper Bell was developed as stated before earlier, and with the progress of horizontal drilling, the Brushy Canyon was for a period of time a very high priority target. Another figure that I referred to would be a figure 4, and that would be 65. And basically what you're looking at is an oversight which goes along with prior witness presented as far as features that have been mapped and let known. Again, this is a reference and something for your consideration should you have questions about what we're working with as far as this injection interval.
Mr. Getz, did you hear yesterday the discussion and testimony regarding lineaments and kind of water movement pathways in the geology that we're talking about?
Yes.
Okay. Are these represented lineaments or these concerns represented in these figures that we're discussing?
They contribute to it, but by and large, our concerns is the relationship. We have historically had Bell Canyon, Jerry Canyon as the preferred injection environments, and we, on our efforts, trying to keep Brushy isolated. But at the same time, historically, this has been difficult with our old methodology of processing permits. And so in many aspects, we do have to rely on the operator to provide us information. So the water flows, the things that we see tend to be a relationship that we have associated with prior injections and have had issues with in certain locations within the basin.
Mr. Getz, in your opinion, what are the necessary takeaways from this paper as OCD is reviewing the applications?
That at this point, when I think we've come through this discussion already, the more information we have, the better we have to understand where injection can occur and be successful and where it can't be. The present system of permitting has not had the level of investigation, and therefore the permitting process itself has created its own problems of not successfully preventing waste, which is one of our directives.
Mr. Getz, I'm going to now direct you to OCD exhibit number 6. And I believe we'll recognize this exhibit, but Mr. Getz, what's depicted here on exhibit 6?
6 is a cumulative representation of information that was compiled beginning in 2016, 2015. It was an effort to qualify what areas of concern operators had, as well as our history of permitting and disposal in the Delaware Mountain Group. Up to 2014, we were seeing increased demands for DMG injection, and we were facilitating that with a very impressive record of permit issues. With it, we ended up with several incidences which caused us to have consternation, to put it lightly, and make us take a step back as to having DMG as a preferred disposal interval at that time. The NMOGA participated in this. We asked them to see what would be an area that would be, especially with the Alon and Upper Bone Springs, and our efforts to get together and come up with an initial assessment resulted in this map. Along with this, I've also added case histories and particular cases where we've had either denial or approval, in which the Delaware Mountain Group was bought either before division or commission.
So, Mr. Getz, I think that you had just testified that there were some areas of concern that resulted in consternation on part of UIC permitting. How are those areas depicted on this exhibit?
We have areas outlined in red. These represents areas where we've had reports of interference either with Bone Springs, or we've had issues with drilling in the Delaware Mountain Group, or in one case, we actually had a disposal well flood. Also, it includes and outlines things an enhanced EOR project, which is in the Delaware Mountain Group. So what we're seeing here is reports and documentation of effects that have been initially related to Delaware Mountain Group injection.
And I think you touched on this, but to be specific, are specific protests depicted on this?
We have a case, it's in the next example. I believe it's in, there you go, getting close to it. In the middle there, that big long yellow. Can you magnify? So, yeah. So he selected what is going to be the next exhibit. And this would be the Bobco case versus Mesquite and Chevron and Oxy with regards to Delaware Mountain injection.
Mr. Tremaine, can you have the witness just explain where that is on the map with the circles again?
Yes, gotta manage my mouse. So Mr. Guest, can you please describe just the shape and location on the exhibit to identify that specific case? As it's currently depicted on the screen.
It's the application to invoke injection authority for 2 SWD wells.
That's the
Yes, that's
central,
correct.
central circle?
Yes. And then the exhibit below it, and then the circle over there, and the cluster of wells.
So this area in the center here that I'm kind of outlining with my cursor, that's the Bobco case and interference issue that we're talking about.
Correct.
And just to reiterate, although they're relying upon us heavily, the other red outline areas are instances of noted potential interference.
Correct.
So in summary, what are the necessary kind of takeaways from this information in terms of how OCD is reviewing applications for injection permits in this area?
At this point, this is one of these areas where we have high concerns about the issuance of Delaware Mountain permits without having some strength of information. We've had applications in these areas, and several of our applicants have withdrawn those applications upon request for additional information. We have had applications outside of the delineated area. Those applications have also been withdrawn. But I think majority of it is that at this time, the division went towards seeing if the Devonian Silurian section was available for injection. And the mass of applications at that time went for the deeper interval. And we did not have as many Delaware Mountain Group applications. However, at that time, during this period, the division did take the opportunity for those operators who had small operations, who had existing DMG wells and had to have them reissued, that we went ahead and supported that effort. We also have had the issuance of DMG intervals for what are known as slurry wells associated with surface waste facilities. And we also had, as the commission knows, applications for the class 2 acid gas wells, which have preferred DMG at this point. And we have used that as an option in locations where we do have gas processing facilities when the Devonian is not available.
So Mr. Getz, a couple more questions tangentially related to this slide. Did you observe and listen to the discussion and presentation yesterday by Chevron regarding all potential alternative interference pathways?
Yes.
Is it your understanding after listening to that presentation that injection interference cannot yet be eliminated as a cause of the interference observed, for instance, in Bobco cases?
I think the Bobco cases are certainly a classic example of cause and effect. There seemed to be little question as to what the source was. But there may be opportunity for many things to contribute to interference, and that we are only beginning to understand and have information to assess what we're observing now. Again, we are deficient in having any type of correlation in some of these cases. We do not know the source.
So is it fair to say that as the UIC manager in reviewing permits, OCD's concerns remain, you still have to manage the permits in this area to account for potential interference from injection?
We do proceed with caution, knowing that our permits, once issued, it is up to the division to pull them back from hearing. The other thing is that, again, being assigned the prevention of waste and the protection of correlative rights, we've had issues where, in the case where the Bobco case exceeded the area of review, in which case that means we have violated that obligation. And in the case of the Bobco again, we had a washout of resources, and again, our protection of the resource and prevention of waste was not satisfied. So we tend to have been more conservative in the issuance of permits in Delaware Mountain.
Mr. Getz, that being said, will OCD consider and incorporate the alternative information provided by Chevron yesterday?
The division is always open to having more qualification, quantification. That helps us in our permitting system, and it certainly helps us in our compliance and our obligations. So yes.
And I think, do you recall from yesterday's testimony regarding the area impacted by the injection intervals? I believe we were talking about a 1.7 mile radius.
Are we talking about spacing and distancing or just?
Well, what I'm getting at is
The distance that the DMG can travel is very good. It is something with the right conditions, again, would exceed the area of review and again, violate our conditions of our permit.
okay. That's what I'm getting at, Mr. Getz. Do you think that Chevron's 2 mile area review is more prudent than the existing standard half mile area review often utilized in SWD applications?
Well, again, that would be prudent. The division has learned from the experience with its acid gas wells, and 1 mile area review has been quite significant and worthy in permitting those. And as certain attorneys in this room know, that the Devonian effort that we went through at division's hearings to establish a 1 mile AOR in order to provide better protection as well as allow for resources to be developed, or the reservoir to be efficiently used for disposal when considering the cost of the well. So we always are interested in trying to provide some sort of management in the sense that the resource will not be swallowed up, I would say, with too many permits in the same location.
So, Mr. Getz, last question on this. Is it fair to say then that provided the uncertainty and the information that we've been discussing during this hearing, that it would be OCD's recommendation to utilize, to consider, or that the commission considered utilizing a 2 mile area review for future similar DMG applications?
It would be worthy of consideration, yes.
All right, Mr. Getz, I'm going to move us on to number 7. Already discussed and referenced somewhat. Could you please summarize for the commission the content of Exhibit 7?
Very good. This was, and this is provided as the worst case scenario. At this time, the division was issuing permits. We were looking at them as a singular event, very myopic. In this instance, we had a cluster of Delaware Mountain Group wells that were approved. Two of them were already in place and performing quite well. A fifth well that was there had been plugged and abandoned. Two new wells were approved. The two new wells, of course, were reentries of older wells. And with the approval of all these wells in this area, we received notice from Bobco that they had issues with wells in their Poker Lake unit in the northeast corner of it. At first, they attributed to injection, and then they finally progressed to filing cases in both the private operator of the two new wells, as well as the existing operators of the two wells that were there prior to, and we'll say in this case, it was Mesquite and Chevron and Oxy. Next figure.
So, Mr. Guest, just to wrap that up, is it fair to say that Exhibit 7 contains the salient exhibits and orders related to the Bobco cases we were referencing?
Correct.
Okay.
It's a snapshot of what happened.
And I believe you were about to refer to the walking through to the next exhibit. Which is on page 97.
So this first figure just shows you the wells that Bobco systems were impacted, the three horizontal, and the location of the four wells and one plug and abandoned well, all DMG injection wells.
And for clarification purposes, these are the same wells in terms of the Mesquite injection wells and the Bobco wells, which were discussed in Chevron's testimony yesterday.
They were referenced, yes.
And kind of skipping ahead, what were the results of these cases?
The results of these cases, the two Mesquite wells, these were an operator which purely was focused upon disposal. They had no mineral interests. The other two wells, one owned by Oxy, one by Chevron, supported their field operations. And so their operation, their well remained intact. They provided information, extensive studies, including fall off tests, Hall's plots, and as well as well bore information, which supported the proposition by them that both their wells were not a contributing factor to the situation that Bobco had in their horizontal wells. The non-operator or the commercial disposal company settled and came to an agreement with Bobco, which resulted in revocation of their permits and eventually the plugging of their wells.
So in summary, certain of the injection wells remained in use and continued injection, while certain other wells were their injection authority was revoked.
Correct.
And are there any kind of salient differences between those wells that you had in the commission?
I believe the cross section is the next figure. Okay, that's the location of the cross section. And the notation, and then that's the cross section. Again, noting to the commissioners, both the Chevron and Oxy wells were completed with the intent of disposal with case and perf intervals, and kept them up in the Bell and Cherry Canyon. The Mesquite wells were approved with open hole section. They were not selected for location. They were just the opportunity to take an old plug well, re-enter it, and get a permit for it. So at this time, we did specify that there would be a plug back in one well, though the paperwork said it was done. The final order for this well was a request to wireline to demonstrate there was plug in there, but that was not done. It's a discussion for another day about wells that are under federal authority versus state authority. But it does demonstrate reason why we're saying we don't want the open hole. We want the cased interval. I think it represents a better management process and controls. If we do have issues, then the perfed casing not only allows for better monitoring, but also it also encourages, if you want to do testing, one of the things we do like to see is injection surveys. And a lot of the pushback we get from operators in open holes, I'm going to lose a tool down hole. With casing, that goes away. There should be no reason why.
So is it fair to say that this is largely the basis for OCD's recommendation that the injection wells be completely cased,
Correct.
cemented, and injection through perforations?
Correct.
Is there anything else that you would like to highlight in Exhibit 7 for the commission's consideration?
And we do have one more exhibit that was Exhibit 18 by Bobco. Again, showing Bobco went in and brought in their information, which they had developed for placement of their horizontal wells. And realized that in 2014, 2015, this was very rare information. So they did formation microimaging, brought in and showed that we had an existing fracture system that no one was aware of. Under our permitting process for the SWDs, we did not entail such requirements. Such information was truly oriented towards production, and the reason why Bobco oriented its wells as it did within the Poker Lake unit for the brushing. So again, the effort by the producer to bring out more detailed information that gave us a greater understanding of why these wells, these cluster of wells, were able to reach so far and have impact.
Okay, in your, just at kind of higher level, and you've referenced some of this, but I just want to clarify for the commission, you know, in your professional opinion as a USC manager, and applicable more so generally to DMG injection applications, you know, what are the lessons learned from the Bobco cases?
We have learned some lessons, but as we move forward in DMG, I think the requirements for better information, for better qualifying are necessary. Old practices will not stand. I think if we're going to be protective of resources, especially, we need an effort to have the permitting process include the operator with greater degree of information prior to any type of approval, especially if we're doing it administratively.
I'm going to direct you now to OCD exhibit number 8. Mr. Guest, what is OCD exhibit number 8?
OCD exhibit number 8 was a presentation given on behalf of the MOGA to the director at that time regarding evaluations that had been done on Delaware Mountain Group, and especially compiling information. This was our first effort to have a snapshot of what we thought were concerns with DMG. One of the issues that we've had both in the injection and testing later through the step rate test and the request for injection pressure increases has been a recognition that a fair amount of DMG in this area has a low formation parting pressure. As noted before, The division, in its agreement with the EPA, under its primacy with the EPA, awards a 0.2 PSI per foot calculated gradient for the maximum surface pressure. This is based upon information from the folks who submitted the original primacy demonstration, and it's served us well. Anything above that, you must prove, and typically it's been with the step rate test, where the formation parting pressure is. And with that, we will prove a increase in the pressure with the safety margin included. The information obtained looking at what was in historically old step rate test as well as production information, and that would be frac work done in Brushy, frac work done in Cherry, that we were seeing that it was considerably advantageous for us to pay particular attention when we get a request to go anything above 0.2. And so it doesn't mean we haven't had areas that shown good quality and an increase in pressure with no problems. But again, we were faced with this fact that we're seeing irregular or inconsistent issues with our own step rate test, and with it approval of pressure increases, which resulted in formations being fracked as a result of injection. So in some cases, in the case of the Bobco, we actually approved a pressure that was not pressure representative of the formation. And in those cases, my interpretation was a pressure representative of the confining layer that was being fractured. So our own process and our concerns were being brought to us that some operators were seeing in interference in Avalon Shale, and some of this was being attributed to the fact that we did allow for pressure increases that were above the formation parting pressure.
So, Mr. Getz, I think you provided a summary of this. Is there any specific areas of OCD exhibit number 8 that we would highlight for the commissioner?
There was. Well, I would, the Road Hills West frac gradient, I believe that's slide 131. Again, showing you the trend. That we were close to the 0.2 PSI. So it's not that we're not aware of it and we do have enough information. The other factor has to be, yes, it's that information has to be specific to the area that we're actually looking at injection. This concept of regional application seems to fall apart, and this is what we've been doing previously, that if we had an SRT in one area, we were extending it in many cases arbitrarily to another well in the same interval. So other than that, basically this information is there for the review, and it pointed out the concerns of the industry at that time with both Avalon and some brushy communication with DMG wells.
So, Mr. Getz, is it fair to say then that this paper underscored or contributed to OCD's review and concerns about permitted pressure and specifically at 0.2 PSI?
Correct.
And is it also fair to say that another takeaway is that the injection wells in the DMG need to be assessed and permitted based on more detailed local geographical information, geological information?
That is correct. And again, this resulted in 2016 to 2017, 2018, with a workshop with operators to discuss this matter. And at that point, again, the division was looking at Devonian as an alternative. And so we still discussed Delaware Mountain Group, but there was seemed to be a loss of interest at that point.
Mr. Guessam, I'm going to move on and direct you to OCD exhibit number 9. Can you please describe for the commission what exhibit 9 is?
Number 9, and this was brought out by Chevron yesterday, is just a highlight to the commission that the Texas Railroad Commission, which has the authority for a 0.5 psi per foot administratively approved gradient to determine maximum surface injection pressure, has mandated that Delaware wells within the seismic response areas that they have, that they're cutting that to 0.25. And it's a discussion that I had with their folks. They felt that it would be best in their interest to at least go to that direction. So we're seeing on the Texas side similar interest in DMG and how to manage injection pressure down there. Again, I would highlight that it's in the seismic response area. And to that point, Texas has also approved larger capacity wells in DMG, but they do not have the constraints that we do.
How does this inform OCD's concern with injection pressure in the DMD within New Mexico?
Well, it supports that our current 0.2 psi is a good place to start. And with that, if you want to go up and above, then the opportunity to test and provide us information that is accurate and provide us with something that we can put into permit and feel confident with and ensure that the injection is confined within the injection interval.
And what are you just referenced mechanisms that might be necessary to support departure from the 0.2 psi. Just at a summary level, what would those mechanisms be? Like a step rate test?
Well, I mean, the step rate test is a classic. DFIDs, we've had DFIDs. They've been used in horizontal ER projects where we've had concern of injection pressure and people are working on larger scale one sections with 2 horizontal wells and Bone Springs. DFIDs have been used in there to demonstrate to us that we're actually getting a proper injection and it is beneficial and we're not fracking. So other information, the Hall law was used by both Chevron and Oxy to defend themselves. In the Bob Hill case, fall off tests have been used to demonstrate to keep flow, radio flow demonstration. So there is a variety of information available.
And we're going to get there in a little bit, but is it true that the SRTs that you referenced in the Hall plots are included in OCD's recommendation for these?
That's correct.
And after discussion we had yesterday, the testimony we've heard, and your consideration, would you support inclusion of DFIDs as one of the requirements for these wells?
I would think that'd be a vital tool.
All right, Mr. Getz, I'm going to move on to OCD exhibit number 10. Get my computer stops moving down. This is another paper, so I'm going to leave it here and ask you to describe for the commission. What is this paper and what is it about?
Basically, it correlates to what has already been presented by Chevron. This paper does highlight the effort to qualify seismicity, the current understanding down there. The reason I brought this to the attention of the commission is that the figure 2, again, giving a snapshot of understanding, we have less concern with regards to seismicity issues with the current understanding and relationships. At the same time, we also note that we've had several operators highlight to us that they've come across faulting in fractional system as demonstrated by the Bobco case. That there is information out there which needs to be considered when we're doing injection in Delaware Mountain Group that may impact how the flow is around that well. Currently, we do not request nor get that information, but I think this is going to be an ongoing process where we're going to see more information come forward. And hopefully, in doing so, we can modify the permit to satisfy those conditions and make sure that we don't have waste or we have flow correlative rights.
If you could check the screen, is this the?
That's the one.
That's the.
That's the one. The bottom cross section. That would be B.
And so if I'm understanding you correctly, is it accurate to say that the OCD's concern is either fractures or faults? Did I get that?
Both. Both of them can contribute. Both of them, again, we want to have a good radial flow out from the well. We don't want it to find something and suddenly take off. So that becomes the management process, is that we do have best quantification, and the permit conditions make that injection live long and does not interfere with correlative rights.
And did I hear you correctly that for a standard SWD application, OCD does not necessarily get information that would depict those faults or fractures?
That's correct.
And what sort of information could applicants such as Chevron provide to the OCD generally to provide the appropriate degree of confidence in identification of fractures or faults in this area?
Well, besides what we've already listed in our exhibit, a lot of the operators in these areas do have information regarding production wells that we put in. I think being able to look through the historical record and see if they have information in the DMG, if it's an application, if they have something in that area, this would provide us with a better picture and certainly a better model as to the effects of any type of fracture or faulting system in the area. And if we do have a good demonstration of no issues, then we can certainly issue a permit with less restrictions and certainly a greater efficiency.
In review of, Chevron's applications in this particular case, it sounds like from your testimony, you're discussing certain things that Chevron may have provided in this application. Are there any areas, such as we just talked about, where it would be beneficial for Chevron to provide additional information?
Well, at this point in time, the list is fairly complete. It exceeds what we had originally thought. So, but the caveat to that is this is why we're asking, and we think of it as a pilot project. Is it going to be necessary for this for every operator inside of the Avalon area? Is it going to be part of our standard operating procedure? What gives us the greatest information and decision making? And what can we approve administratively, and what do we need to go to hearing for? So I think beneficial for both the operator as well as our obligations under statute. This is something that we'll need to have in the future if we're going to utilize the Delaware Mountain Group for expansion of disposal.
Mr. Getz, you just brought up the pilot project concept here, and I'm hoping you can provide your perspective to the commission on in the context of a saltwater disposal well. If there's anything to add to previous testimony, what is the significance of this pilot project?
It's a tricky question. It is not uncommon for the division to go to commission or its own division examiners to establish a record. And in this case, we've had limited DMG injection. And so we know our shortcomings, but at the same time, if we're going to move forward with DMG injection, the opportunity to put into record at least some quantification that we can use in our permitting process without going to rulemaking gives us the opportunity to move forward and utilize this as a guidance. And I think that's the most important thing. Once we've established a pattern, it gives us a level of confidence that we're protecting relative rights, that our AORs are being met as far as notification, as well as issues of how big the plume can be or how far it goes. The pilot project at least lays out a pathway, and it also allows us the opportunity to make changes. If we find something better, if we find even a more accurate process, or if we've got a problem, for instance, in a certain area, that we can come back to the commission or division and say, the protest, or say, we just don't want injection in this area because we have problems.
Is it fair to say that there are certain factual patterns or contexts where OCD might consider approval of administrative conditions, but there are other fact patterns which UIC believes may need to come before the commission for consideration?
I'm sure there will be situations where we will have a request from industry that will come back to the commission or division to make a case, either, and typically it's either to get more information or in the case of opposition to having that permit issue.
I think this is a good time to segue to OCD exhibit number 11. Mr. Getz, is it accurate to say that this is this is a list of conditions or guidelines that OCD would be proposing in the event of an administrative DMG SWD approval?
Correct.
Okay. So with that as a preface, it would also be accurate to say that applications such as Chevron's applications that depart from certain of these conditions, such as location of an injection well within that have a proposed Avalon protection zone, that's one of the primary reasons why this case OCD feels should be currently before the commission.
Correct. The concern was that it's in an area that we've had very poor experience in, and had at this point not necessarily had a prohibition on, but necessarily felt uncertain as to how the permitting process should proceed.
So based on that and the concerns you previously outlined, is it your opinion that, additional, we'll get to the content of exhibit 11 in a second, but the overarchingly, because of the factual context here, OCD feels it's appropriate to require additional information, additional conditions and guidelines relative to what's currently being required for instance, a Devonian injection well.
Yes, I mean, we can even take it farther. Our slurry wells in the Delaware Mountain Group, we ask for more information of those, and we include more testing with those. And with the Devonian wells, the information, including induced seismicity assessment, and to the extreme, the acid gas wells, where we're looking at long-term injection of something that's hazardous. So what we have tried to do is now provide at least a base level of information for the applicant that they know about prior to coming in and submitting a C108.
All right, Mr. Getz, I'd like to kind of walk through in a little more detail. So that, exhibit 11 is really the substance of these requests related to these cases and kind of outlines these plans. So if I could highlight to you, direct you to paragraph 1, criteria selection. If we could briefly walk through and identify the kind of the basis for each of these requirements for the commission's review. So I think we've already talked about this in some detail. So 1A, we're talking about Avalon production. It's fair to say that that is simply identification that, you know, given the information currently before the division, OCD and USC group in particular don't have adequate information to administratively approve injection wells within the Avalon protected area.
We don't have sufficient information to have a level of confidence to issue a permit that we feel will be correct as far as protection of relative rights, as well as keeping injection interval confining layers correct.
Okay. And then in terms of the 1B, this probably speaks for itself, but OCD is not going to administratively approve locations where wells have previously been denied, and that's going to apply to either OCD or OCC hearings.
Yeah, pretty much. The majority of them are OCD. I mean, yeah, division hearings. Commission hearings are very rare. And I think there's only 2 or 3 cases. But I think the vast majority of it is division hearings. So if the commission wishes to include commission hearings, mostly it's about division. And most of that is about use of old wells for reentry and injection.
So in an instance where there's a well proposed for an SWD and it's rejected, any future application for that location would have to come before the commission.
We'll leave that up to the commission, but it should go to hearing, whether it be division or commission.
Okay. And if you could speak a little bit to the 1C here, the exclusion of locations that have demonstrated water flows and problems.
I think it's just practicality. If you're looking at putting a well in an area where you've got somebody already reporting issues, I think it just, why go down that road again? So is there a debate about the little circles? Yeah, there is, but in general, you're already got existing injection in there already. So chances are that you're going to get additional injection DMG in that area is low anyways.
Could you now kind of explain OCD's thinking with 1D, this uniform distance between DMG wells?
Well, the Bobco case showed us that putting them too close to each other was a good synergistic effect. We've also seen similar issues with the DMG wells on the Texas side, where they are clustered right up to the state line, as well as many as 4 in a section. And so with that in mind, the balancing act of starting off with distance and using that as a way to make sure that whatever the operator chooses for injection to DMG, that we're going to have a successful well. We're going to have a reservoir that's going to last for a while. We don't have this synergistic effect. We proposed a mile. It may be greater, it may be less, but I think that's one of those things that the Chevron experience will show us, as well as some of the other information that we're gathering from other operators who are proposing Delaware Mountain group injection.
Is this a recognition of concerns about the impacted injection area expanding beyond, in the DMG expanding beyond the standard area of review for SWDs?
Right now, we have a standard 1/2 mile for anything outside of Devonian and not acid gas. This is our primacy agreement. There is concern, and if we get into an argument about whose well it is, the spacing of the wells gives a greater ability to at least concede, or at least have a management decision as to how these wells should be operated.
And based on the testimony you heard yesterday and our discussion today, the And the area of impact described by Chevron's presentation, would OCD support expanding this to 2 miles, such as the area review utilized by Chevron?
We are always willing to look at the greater distance between wells.
I could briefly explain to the commission the purpose of 1E, this 3 mile exclusion from a gas processing facility.
This was our best estimation. The acid gas wells, as you all are aware, have had difficulties with deeper injection. We historically do have DMG in the earlier days, and then we went Devonian. As information is developed, and again, these gas processing facilities are located landlocked investments. They are critical to production. And the operators of the gas processing facilities have utilized injection means to alleviate their flaring issues. The opportunity for over a life of a plant to have several wells as the reservoir gets filled up and being available for them to utilize the same DMG interval, we kind of would like to have that buffer and that ability for the gas processing facilities to be able to have some window of opportunity. Otherwise, we will end up with this conflict of disposal.
So essentially, OCD is attempting to limit or eliminate the overlap of produced water injected zones with acid gas injected.
Correct. We had this already in one of the commission hearings with regards to a saltwater disposal well in proximity to an AGI well, and the concerns that it will affect the plumes and the relationships, especially in the model for the gas plumes. So you can't pull back a permit. It's better to start up front and say, we're not interested in permitting this area.
Moving on to paragraph 2, criteria for selection of injection interval. What's the purpose for the exclusion of Lamar limestone from DMG permitted SWDs?
The permit is issued for the interval which receives the fluid. In this case, for clarification, we don't include the confining layer in the permit. In other words, the Lamar will be, and the Castile will be the confining layer. Therefore, anything below the Lamar would be considered the injection.
Are there any concerns or necessary corrections that OCD would point out in Chevron's C108s related to the Lamar limestone?
Yes, it seems to be included in the permit in the advertisement. So when you advertise this, this is what goes out to the public. Therefore, we're saying you can inject into the Lamar. I don't believe this is Chevron's intent, and I think this is more of an administrative correction.
Okay, so for the record, OCD is not in support of a C108 application that can be read to permit injection into the Lamar limestone.
Not as well as we not would permit injection into the Woodford. We use it as a confining layer, so it's not part of the injection area.
But Mr. Getz, with that clarification, did I understand correctly that you believe that this can be corrected through administratively communication with Chevron in this particular instance?
I believe if we have a discussion with them and they get more clarification, that this could be done with just a correct wellbore diagram. Under the UIC rules, expansion of an injection interval requires notification, but since we're contracting it, the area is already covered, so it'd just be a correction to meet the technical requirements.
All right, so moving on to the lower Brushy Canyon, if I could summarize, is it accurate to say that there's a similar, OCD has a similar concern related to the lower Brushy Canyon?
Correct. The application essentially goes down to top of Bone Springs. And so again, we would ask Chevron to provide us with a confining layer. Raise your hand.
I'm paying attention.
that the lower description, the lower confining layer be better qualified, and we'll modify the permit to again give that bottom injection interval. The way it stands now is that we would be improving everything from the bottom of the Castile to the top of the Bone Springs, which is not real.
So with that clarification for the record, again, that similar to the Lamar limestone issue, the top confining layer, this is something that OCD believes to be corrected administratively.
That's correct.
And could you briefly speak to 2C, the area of review and how that specifically applies for the DMG applications?
Again, what we're trying to do is in our discussion in the exhibits before, the fact that there be information available, again, the operator being one that already has or has access to information which may be relevant DMG for fracture and faults, that the operator provide that information and then give us an assessment. At this point, we still look through the realm of doing some sort of seismic response or seismic evaluation. At this time, the current information we see is not a concern, but we still go through the process of demonstrating the zero, and therefore take the risk element out of the permit process.
Right. Moving on to paragraph 3. Could you please clarify the purpose of 3A, distinguishing new well construction from existing well construction?
The greatest problems we've had with old Delaware Mountain Group disposal wells historically have been to go and put new perforations in old wells. And so we inherit the problems of the old well, especially for things that were done in the 80s and 70s that went down to Morrow, Atoka, Pennsylvania, drilling out plugs and then perfing the old casing was a very popular economic approach. Since then, we've had several attempts for Cisco Canyon to re-enter, only to have dismal failure in the wells plugged with the top surface casing not even being able to be cleaned out. So current events and historical would say we'd start with something clean. Let's find a location. This, I think, also offers the operator the ability to select a position or a well surface location that's better suitable for their operation as well as what they have subsurface as far as geologic information.
Mr. Getz, can old wells or what they're calling a converted production well to a SWD well, can those old wells be tested as effectively as a newly constructed well?
There are limitations, and certainly you can do a variety of logs, but with historical records, again, sharing well information with the federal folks. A lot of times we have a lot of gaps when we do the review, especially for an application. Without that information, you really can't make an accurate assessment, even following with integrity logs, these sort of things. It just doesn't, you're really throwing money down the hole, and starting with something clean is much more beneficial.
Moving on to paragraph 3B, why does OCD want to limit the outside diameter for injection tubing to 5.5 inches?
Currently, this has been our most successful. There has been proposed to go to 7. There have been proposed to go to 9-inch. But following the Devonian case before commission, find that the 5.5 at this point is pretty standard. If we wish to go above that, then let's go to a hearing.
We've had some discussion about 3C yesterday. Could you please summarize for the commission the purpose of 3C? Really, what's the distinction between frac jobs and acid jobs that are considered?
Well, the world of well stimulation has many terms. And so all these wells are going to be vertical wells. You do have people talking about horizontal wells, but we'll worry about that. That's some other day. But with the well completion, there is a certain amount of well rehab that has to be done. And so the use of an acid and pressurized and pushed out through the well into formation is an accepted practice, and we don't feel that it really takes away or diminish the quality of the reservoir. The concern we have at that point is that your pressure for the acid job doesn't compromise the well integrity, the cement job, that sort of thing. And it is a standard practice. So what we're trying to avoid, and we've had this issue that some people have gone ahead and actually have fractured and then maintain the fracture systems with proppants. This dramatically changes the characteristics of the reservoir. And so with it, the injection radius as well as the injection pressure. And later testing becomes questionable at best.
So based on the information currently available to the OCD, the acid jobs such as are considered proposed in the Chevron applications, those are not likely to propagate fractures within the injection layer.
That's correct.
All right, I want to move on to paragraph 4, additional testing and monitoring. We've spent a lot of times here talking about this. We could run through. Is it fair to say that the recommended cement bond log here in 4A is in addition to a typical cement bond log requirement?
Correct.
Okay, and what's the purpose for that?
To have a good record, if there's questions, we've had issues with even surface casing not being properly installed. Down the road, we will have complete record and certainly no questions about the accuracy of the cement work on the well.
And Mr. Getz, what's intended or required under 4B, the suite of open hole logs?
Again, historically, disposal wells, many of the operators who come in and just put them in do not conduct any type of logging. And so with our requests for a higher information, certainly the log suites would be beneficial. And of course, with that also is the requirement that they be submitted to us. So we will probably have to push on the BLM on this issue, but by and large, which have some downhole information. So as a minimum for other operators.
The common theme for this hearing that more data is needed for the DMG.
Correct. For permitting issuance, yes.
We're going to talk about SRTs in more detail in a minute, but if you could very briefly summarize the need or purpose behind 4C, it's a requirement for step-rate testing or injection.
Yeah, I think this has been one of those things that historically, we even had recommendations from other operators is that step rate test be done with initial well conditions, with initial reservoir. We historically only had the request or a need for a step rate test after the well has built up pressure and you're reaching that 0.2 PSI grade. And so let's start off knowing where we have a formation parting pressure, especially in light of DMG having the opportunity for a low formation parting pressure, that this information be available and that way the operation of the well, both the operator and the regulatory group knows what direction we're heading.
And is it, we've discussed this, but to just clarify, it would paragraph 4 here be the appropriate place to amend to include the requirement for DFIT tests?
Yeah, any additional testing would be considered under this category, certainly.
Could you briefly speak to 4D, this requirement to obtain static bottom hole pressure, et cetera?
Well, this may become a great rail of information, both in the Devonian cases as well as we used to get bottom hole pressures for the gas wells and production wells. We have since lost that interest or need. I think this is going to be helpful in regards to issuing new permits in areas that better understand the opportunity for increased injection. So again, bottom hole pressure information is critical, and you see it as a very, very good tool. And best way to get it is by saying, put it in a permit and give it to us.
Could you please briefly speak to the need in 4D for public seismic monitoring station?
I think this is an opportunity in Texas. When they did in 2018, their phase in of Delaware Mountain Group, they broke it into 3 volume, 10,000 barrels per day, 20,000, 30,000 barrels per day grouping. It was noted that for the 30,000 barrel per day, that you were requested to put in a seismic station for that well. Seeing how we are in an area that is overlain by a variety of private arrays as well as multiple injection intervals, I think it is best for the division to move forward and at least fill in the gaps as the state seismologist sees needed, as well as provide public information that can help assist us in better managing. Should there be an issue with seismicity, that it may not be related to Delaware Mountain Group, but at least we have a location where we can get a better picture of what the source is.
Mr. Guest, could you please speak briefly to the 4 pad, the reasoning for kind of establishing the use of existing DMG disposal wells as observation well?
We have had inquiries from operators to take existing Delaware Mountain Group wells, disposal wells, and convert them to observation wells, whether putting down bottom, what you would call pressure bonds or transducers, to actually have information. Most of it is being done in an effort to better assess the impacts, not only to, well, primarily in some cases, the drilling, if there's problems with that, but also resource protection. So the opportunity to take existing Delaware Mountain Group wells and convert them to observation wells is a golden opportunity. But at the same time, we will have to modify our rules since this would take this well out of the beneficial use, probably create an inactive well situation, that sort of thing. So we would probably seek administratively the opportunity for operators to convert a disposal well and turn it into an observation well and still maintain bonding and keep it off the inactive well list.
Mr. Getz, in terms of Exhibit 11 overall, I just wanted a couple of clarifying questions. Inclusive of any modifications to this document that are informed by this hearing, is it true to say that this is what OCD would intend to utilize as guidelines for administrative approvals, assuming the pilot project went forth successfully?
Correct.
But also to clarify, variations from this administrative approval guideline document could be approved by this commission. in future cases.
Yes, and I think that's one of the benefits of the pilot project. If we find a tool in there that's very beneficial, let us go ahead and utilize it as part of the administrative process, and therefore remove the necessity for hearing. And again, for management.
And again, the guidelines that are laid out here in Exhibit 11, is it true that these are intended chiefly to assist the OCD in acquiring data that may be necessary to assess both permitting conditions, but future potential causes of observed interference?
Well, both the permitting process and the compliance process. We are required under EPA to review the permits every 5 years and see if the conditions have been met. And otherwise, there may be an operator who'll come forth and say that we do have a situation. This is one of the things that was brought up in the Chevron process. If it's such, we're going to be a participant because it's the injection authority of the OCD under the Oil and Gas Act, which would come into question.
And Mr. Getz, in your opinion, we've covered the fact that these guidelines are specific to the Delaware Mountain Group, and they are largely beyond what might be required in some other saltwater disposal permits. So is it your testimony today that these additional conditions are warranted due to the concerns that have been highlighted overall in this hearing regarding a lack of data regarding features in the Delaware Mountain Group, concerns for correlative rights, etc.?
Yes, and I'll add to that. The DMG is becoming again a focus for disposal, and with it, the necessity to better qualify. And realize that Chevron is not the only applicant and not the only type of applicant. We will have bid streams who will be looking at investing large amounts of infrastructure as well as well structure to accommodate other operators who no longer carry their own disposal. So they are gathering at the gate to see what comes out of this, and with it will come a wave of applications. And I will further emphasize this with the Devonian. See, in 2018, we had 45 applications, and the following year we had over 553 applications.
So is it fair to say, Mr. Getz, that
Keep going.
is it fair to say that the content of Exhibit 11 is going to be critical for the OCD moving forward in terms of establishing a floor for acceptable permit applications within the Delaware Mountain Group?
Correct.
And you just testified to the kind of one of the primary drivers here, and I think we heard some testimony to this effect yesterday of the need for produced water disposal in the southeast. Is there any other information you'd like to provide to the commission to kind of put the scope of that driving need in context? Like, what's the scale that we're talking about here? The potential scale for Delaware Mountain injection?
Well, it'll be expansive and it'll be exponential. My concern is that Chevron's attempt to qualify and quantify will have to be contiguous or in cooperation with a demand that will come up for Delaware Mountain Group disposal. The historical amount of application by some operators to have 4 wells in one section has already been laid out back in 2018, 2019. And so this will be a big alternative to Devonian, and with it, the concern that we do at least get a handle on it so that we do manage it properly. We still will have Devonian, we still will have Cisco, we still will have Avo, we still will have other areas, but the greater basin with the Wolfcamp play and with the Bone Springs play, the capacity need is there, and this is at that point, one of the alternatives that's been offered.
Mr. Getz, do you recall, yeah, I want to address this question of like maximum injection volume versus pressure. Do you recall that question yesterday from Commissioner Alonso?
No.
You cannot. Well, I strike that, and I'll let him phrase the question. This will do it better than I will. Okay, so
Well, I mean, there is a relationship for volume and pressure. They're related. And so the concern, I guess the question was the permit, the amount asked for. And this has been probably a poor historical aspect of permitting process. Tendency is I would see applications for 50,000 barrels a day for every well that ever came in. And it's not realistic. We understand that. We have been trying, especially for the Devonian wells, to finite this to make it more accurate, especially when we ask them to look at how far over a 30-year life, how far that fluid would move out and where these wells would interfere with each other. I think for the DMG, we're going to be faced with that same issue. Some people will lay out an area and will probably be realistic about what kind of volumes they can put in. My 10 years with OCD, if you get a 10,000 barrel a day, it's fairly good. We do have some to achieve 20,000. But by and large, that's the room we work in order to protect relative rights and not have fracturing. Again, Texas does not worry about relative rights. And with it, the ability to do 30,000 barrels a day with 9-inch casing is a reality.
as proposed by, these terms that are laid out in Exhibit 11, and the existing injection pressure set by OCD, will the limitation on the casing diameter and the pressure effectively limit the injected volume?
I think it'll be beneficial for us at this point to work with what we know. And so we've had success with this in the San Andres, which has its own issues. But if we were trying to go bigger, I think we need to take a step back, and that has to go through a hearing process.
And I think the last question, Mr. Getz, or a couple of questions with one topic. What, if approved, if these applications are approved, what will be the approved term of injection authority for these wells?
Currently, in 2020, we reworked our permits. Our former UIC permits that we issued were of poor structure and did not incorporate many of the rules that we have from the EPA. The current permit template includes a lot of the mandatory language that we avoided. And with it, we added a 20-year limit to the permit, and at that point, renewal. Prior to that, it was until either you exceeded the formation parting pressure or the well fell apart.
Given all the facts presented in this hearing, would you recommend to the commission any modification either to that term of injection authority or a term of monitoring, reporting, or reconsideration of the permit?
In our rapid discussion this morning, I think the term of a 20-year permit is good, but require reporting on a frequency. I think, and this will be the pressure of Chevron, is that every 2 years we get some sort of summary report, because we're going to be using this for guidance. We're going to be using this to develop our own criteria. So there should be no real reason to, if the permit is bad, the well is bad, if it's 20, 50, 30 years, it doesn't matter. But as far as investment, 20-year represents a good business investment. And then the condition of approval, we require a more higher frequency of reporting.
So if if the commission adopted a 2-year reporting requirement, reporting back to the oil, reporting certain information back to the Oil Conservation Division, what would your recommendation be for the mechanism for OCD to act on, if necessary, on that report?
Well, I mean, well, there is the sitting down and negotiating with the operator, but the final ultimatum would be go to hearing. I think working with the operator and making a presentation to the director, since it is an order signed by the director, as an alternative to hearing, is more practical and certainly more frugal with regards to staff and management funds.
So ultimately, the division recommends that this reporting and monitoring be delivered to the Oil Conservation Division, and that could ultimately, if necessary, be elevated to the commission.
Yes.
And with that, Mr. Chair, I am done with the direct examination. Thank you.
Thank you. Ms. Bennett?
Thank you. Thank you, Mr. Getz. Thanks for all that information. I appreciate the opportunity to be here with you.
Mr. Chair, can I ask for a 10-minute break before we begin?
All right. We will do a 10-minute break. We will resume at 11:10. I'm going to mute the room, but otherwise we can going.
Was flagging.
Got to.
All right, welcome back, everyone. Actually, let's give Commissioner Bloom 1 second to return, but we will go ahead and get started momentarily. Just a moment for those online.
Any questions?
I think this
That's it. That's it.
This is really about like more questions from my handwriting, so I have to rewrite.
Mr. Tremaine, while we're waiting for Commissioner Bloom to return, we do have a quorum. I understand there's an administrative matter we need to take care of before cross.
Yeah, similar to the matter earlier, I had intended to move admission of exhibits 5 through 11 prior to releasing Mr. Getz, but unfortunately I let him ended direct. So I would move now admission of OCD exhibits 5 through 11.
Any objection?
No, objection.
Those exhibits are accepted. Ms. Bennett?
Thank you. And thanks again for being here and for all the thoughtful work that the division did in preparing for the hearings today, as well as in meeting with Chevron. Really appreciated. Just a few follow-up questions. It sounds like the division and Chevron are aligned on the need for additional data in this area. Is that an accurate statement?
I think it's reliable to say that for the permitting process in general, we need more information.
And as I was sitting here, it sounded a little sort of like a catch-22 or a chicken and egg situation where the division would like additional data, but that additional data needs to come from the ground information due to the differences in the complexity of the geology and things that you were mentioning earlier.
Historically, this has been our approach, that the operators provide us with the information since we cannot collect it, and therefore provide us with the basis for making a decision. So this is not uncommon.
And in your testimony, or actually one of the, you noted that there was a benefit of the pilot project was, or a benefit of the pilot project is this data gathering opportunity.
Yes, it is always great when we have an operator come forward and invest time and effort to better qualify and quantify, making our process better.
Would you were here yesterday when the Chevron witnesses were testifying, is that right?
Correct.
And do you recall testimony that one of the reasons that Chevron picked these 2 wells for the pilot projects is the difference in geology as between the 2 wells?
Yes.
Do you view that, in your opinion, as a benefit of the pilot project having local area information to be provided?
Well, I look at it as a process that we can copy with other locations within the DMG. The fact that they chose 2 different types of areas would indicate to me that in an effort to expand this process and expand disposal, they selected 2 good locations that they felt they had good information on, as well as the potential for more disposal in the same area. So, yes, choosing 2 different types of examples.
And one of the other bits of information or testimony that we talked about yesterday was the fact that Chevron has operational control over both the SWDs and their own producing wells, which seems like an additional benefit to the pilot project. Do you have an opinion on that?
The only thing I would say to that is, yes, that is beneficial for Chevron in its position. But again, our application will be to other operators who have absolutely no production history. That the midstreams are not interested in that, and so what we can take from this and provide as a criteria for those who are currently in the market for disposal is beneficial.
So would you say that Chevron's role as the sort of managing both the SWDs and the producers will then give the division additional information it can deploy when faced with applications from operators who aren't similarly situated?
We can try and see. Again, the relationship of having an operator whose vested interest is to continue their production is much different from an operator who's merely metering water going down.
Earlier in your testimony, you discussed the 0.2 pressure limitation. And it's your understanding that that's what Chevron is proposing here.
We may have opportunities. The most prominent in rule we have is pressure limit. So yes, pressure equals volume.
So the fact that Chevron is proposing 0.2 PSI per foot is consistent with the OCD's requirements. Is that right?
Every permit that we administratively approved under our primacy is at 0.2 PSI per foot.
Earlier today, you were asked about DFIT, and you indicated that it could be beneficial for the OCD to consider including that as a test in the administrative application checklist.
Correct.
Are you familiar with DFIT tests yourself?
Yes.
Is it your understanding that a DFIT test injects a minimal amount of water for the test?
It is a different test, and it does provide a better accuracy as far as the formation characteristics. So no, we have no concerns. Is it substitutable? I mean, can you replace an SRT with it? That's something we can discuss, but definitely having seen it in the enhanced recovery side, we're confident in its results.
Great. And the division doesn't see any concerns with the DFIT test in and of itself?
Well, no, as long as we do it right. Thank you.
One thing that you mentioned in your testimony is the need for a complete and robust application materials. And when you were speaking, you mentioned that Chevron has met a lot of the OCD's expectations for applications and in some cases exceeded that. Is that a fair refresher of what you said earlier today?
Chevron does provide accurate and good application.
And Chevron, you heard earlier or yesterday that Chevron is supporting industry collaboration in this process, which would be beneficial in my view for the division, but how do you view that?
I have no opinion on that.
How about, do you have an opinion on whether industry collaboration with the OCD is beneficial?
Well, we always do. I mean, every process we've gone through, we have gone to industry to get at least a snapshot in the position and the opportunity for additional means to identify problems and resolve them. So no, we've always had that.
You also mentioned that having a pilot project is not uncommon to establish a record and to establish a path forward for the division and the commission.
Correct.
And that the learnings from the pilot project can then benefit the OCD and the commission by providing, I guess, like stepping stones for guidance or information that you can then incorporate, the division can incorporate for guidance as it moves forward.
Not only that, but the foundation for the ask. I mean, we do have this debate about policy and practice. Yes, we don't. Yes, we do. And we use the commission's findings as a means to show justification for either a requirement for information or some sort of testing or monitoring as part of the permitting process that we may approve administratively without.
I found the discussion of Exhibit 11 to be particularly helpful because that is a checklist for administrative applications, or that's the intent of it, Exhibit 11. A fair statement?
It was a fair statement to provide a basement level of what we're looking for in DMG.
During your testimony, you mentioned that the division's goal is, or not goal, but desire is to have good wells with long injectivity lifespan. Is that fair?
We look at utilizing the resource of pore space, though we don't have real authority. The permit does have to comply with the statute. In doing so, we get better results as far as using resources. So it goes hand in hand.
Would you agree that based on the testimony that you've seen from Chevron yesterday in their exhibits, that Chevron is also dedicated to having successful wells?
We never said they were.
No, I'm not trying to trap you. I'm just,
No, the effort by Chevron is admirable, and they are putting together something in support of their operation, what I expect out of a business that wants to move forward and continue with the expansion of their operation. So, yes,
great.
this is a Chevron commercial.
Well, if we were at the state fair. And thanks to Chevron for sponsoring the state fair, by the way. I think that might be it. I guess in conclusion, it seems to me that one of the takeaways from today and yesterday is that there's been an evolution in thinking, not just with operators, but also with the division, given the need for additional disposal options. Is that how the division is looking at this as well?
Well, no, we knew this was coming Sunday. Realized the push of voting was something that was identified in '83 in our premise. The concern and use of the San Andres was also identified in '83. We've gone to other locations and other horizons. Devonian has its place, but it does not adequately need support that is necessary for disposal. I think this breather we've had with the Delaware Mountain Group is not only reflective of our change in how things are done, especially when we were issuing permits with the smallest amount of information. I think also it represents a big change in the industry too, of horizontal drilling and what's coming out of horizontal. So to meet that need, we knew we were coming back to the Delaware Mountain Group. We just needed to know how to do it without us sacrificing our demands under our statute. And that's the thing about it. So we may have agreement between operators on how to do something, but it does not take us out of that prevention of waste and protection of collateral right. Protection of waste, but preventing waste.
Mm-hmm. Thank you. Those are all the questions I have.
Sarah, do you have any questions?
Do you have a few?
Yes.
Thank you.
Hello, Mr. Getz.
Hello.
Few questions for you.
Thank you.
Regarding OCD Exhibit 11, which is the proposed conditions. On paragraph 1A, is it correct that a hearing will be required for applications to inject into the DMG within the NMOGA RA?
At this point, that is how we would probably handle it. Since administratively, we do not have resolution. We would like to go back to NMOGA, and I believe there is an effort to review the map as it was originally presented. So this is an ongoing thing, but I think we need a little bit of breathing room. And if we're going to do it administratively, that we have things in place where we know we have concerns for compromise of resources. So yes, it'd be through a hearing process.
Regarding paragraph 2B, is OCD distinguishing between the upper and lower brushy canyon?
I think that has to be handled on a case-by-case basis, but yes. If my preference would be stay out of the brushy as much as you can. And with that, using the brushy, the upper brushy as a sort of a safety zone and very much excluding what has historically been production, which is the lower brushy.
One of Buburn's recommendations, which I had mentioned in my opening statement, is for OCD to work with the NEMOGA DMG disposal capacity reexamination work group to create a DMG type log and stratigraphic cross sections to ensure consistent DMG layer picks across the basin. Is that something OCD would consider?
We would consider, and we also have plans to work with the Bureau of Geology, the Mexico Bureau of Geology. We currently have a task agreement with them, but they assisted us in the Devonian projects. We are also looking to them to assist us in Delaware Mountain.
Buburn has also recommended that OCD consider the requirement to perform a new step rate test anytime the tubing diameter of the well is upgraded, or if additional DMG perforations are added below the current disposal interval. Sorry. It's been a long. Is this something OCD would consider including in Exhibit 11?
Currently, our step rate tests are conditional, meaning that if you move the packer, you change the tubing size, or if you've added perforation or open hole configuration is different from the original test, then you have to run another test. So we would carry that through.
There seems to be a misconception in the industry that OCD banned all new DMG SWP permits after the creation of the NEMOGA map to Exhibit G. Can you confirm for the record that OCD never approved rules to ban those new DMG and SWD permits?
No, we did not. Many of the applicants, when asked to provide additional information, withdrew their applications. So, and in some cases, the companies dissolved before the permitting got done. So.
Regarding OCD Exhibit 8. We're looking at pages 12 and 13.
Mr. Tremaine, could you bring up that exhibit?
Yes.
Those pages appear to address the same case or a similar case to that presented yesterday by Chevron at page 121 of their exhibits. And I can actually show that to you. That would be this. Do you have it up, Josie? This is the
Yes, that is
Meridian Chevron exhibit.
Mhm.
Okay. Chevron attributed interference between two DMG SWD wells and an Avalon producer to lineaments or faults. Are you familiar with those two SWD wells that are shown on Chevron's exhibit, page 21?
See down there near the pot of squirrel. No, I probably know where they are, but I have not looked at them in detail.
And what is your opinion regarding whether the injectivity of SWD wells can be enhanced by the presence of faults or lineaments?
This is something that weighs heavily with regards to the characteristics of the reservoir. Yes, again, I've had actual water floods north of the Avalon in the Happy Canyon area, where Dollar Mountain Group injection from an SWD well has been observed in a water flood a mile away. So it was indicated by the operator that there was a fracture pattern, but it was never disclosed until the addition of new injection wells. So yeah, it is a heavy item to consider. And of course, the ability to get that information is critical. Will we get it? Again, that we don't know.
And could the potential of that relationship be used as a monitoring tool for potentially problematic wells in the future as more wells are drilled?
Yes, it would be, and again, I think this is the division moving from its well by well approval process, that if we do have an operator in an area, that we become more familiar with it, certainly we would have less hesitation if we knew more about it. But if we find concerns, if we do find issues that it does impact other wells in the area, then we would certainly move towards saying that this is not a preferred area for DMG injection.
Those are all of my questions. Thank you very much.
You're welcome.
Dr. Impoma?
Hi.
And now Phil will talk to me. Yeah. So thanks so much for your testimony because it clarified a lot of things, at least for me. But I do have a couple of questions. Now, with regards to this pilot project, does OCD understand the timeline for this pilot project?
We have, in the past, put limitations on the pilot project in the sense we would say for so many years, we'll keep this in place. This commission reporting back to the commission, we'd still go ahead and issue our standard permit. But at that point, we would release the requirements for commission hearing and maybe do something more aligned with just a summary to the commission. So there are opportunities with the commission to lay out an initial period where they have to come back and report to you as well as us. And then at that point, decision by commission, and it's no longer needed. And we can move on with something else. My recommendation to use our UIC template allows us to incorporate a lot of the necessary reporting informations, the condition for inspection, changes to the permit, these sort of things that are customary for all our class 2 wells, disposal wells. Unlike the acid gas wells where we have that long document with the order and the conditions in that order, we could do the same thing of combining our existing template along with the direction from the commission to have a reappearance and present the results of the investigation.
So with that information, because I didn't get all that information through the presentations throughout, so is then MOCD going to guide the commission? Going to work with the commission to come up with that?
What we would be asking the commission to do is to sanction and say this is a good process and the division should follow. This is why we have the acid gas wells come up, because we were issuing them with the same amount of information requirement we were for a little disposal well. And it was quite clear it was not sufficient with regards to how these wells impact their longevity and what they inject. And so we kind of based upon that approach that for now, for Delaware Mountain Group, if we're going to ask for conditions on a permit, we'd ask the commission to say, yeah, these are good. And presenting, in the case of Chevron, coming and providing a summary report or results, and we would be, again, the same, give our opinions on those results on a 2-year phase or every 2 years for 10 years or what. That we would be able to have you at some point say the level of confidence of what we have in place is good. And the only time we come back to visit you is we've got a problem and we see that we're not really sufficiently adequately guarding resources. Otherwise, we run into this problem of we can ask for things, but legally we are bounded by what's already in our New Mexico Administrative Code. And so our concerns are we don't want to put everything in the Administrative Code because that limits us. The requirements for casing designs and things like that are done through approval of API standards and industry understood. And the same thing is true with this. When we do our acid gas, we usually have the redundant wells approved administratively. But we use the guidance that was given to us in that original order that also applies to that administratively approved second well. So our concept was to go forward with the commission and say, what are we going to ask for in the Delaware Mountain Group? And what can we then go forward and say, if someone comes in and wants just to administratively approve it, these are the things we can do. And we don't get a lawyer saying, no, you can't do that.
So those conditions of approval, is it the one in exhibit number 11?
We can include that in whatever Chevron wants to.
So also, in terms of the condition that, let's say, we are going to establish to support the pilot project, is there some guidance or the commission has to come up?
We could. Historically, you've also been able to tell the lawyers, right, it's an order. And, but I think what I would like to do is go through the UIC permit, add the conditions of approval, and slap that on the back of an order, which we do already. And that commission order gives the guidance of coming back and saying, follow this permit we put together, come back in 2 years and give us the results of this. And the division will show up and they'll show up and we'll find out what's working and what's not working. At that point, you could say, come back in another 2 years. But my concern is that, again, as soon as word is out that Chevron has a pilot project, you folks are going to be busy. And I don't think that's what we want to do. I think what we want to do is get it into a process that even at division hearing level, we can say, look at the commission decision, and this is what we want. Or as administratively, permit comes into us in the office, we find all this information, and we're comfortable enough to issue a permit for what they're asking for.
Thank you. Okay. Let's talk a little bit about the point 2 and then also the injection rate. So Chevron went very hard, they present the RTA analysis. From my opinion, I'm trying to relate that to, let's say, the current location that they are looking at, which I feel like there are some few issues with that. But based on your testimony, you said that you are mostly interested in the point 2, more like the pressure limitation. So are you saying that you feel comfortable for Chevron to put in 20,000 for one well and then 15,000 for one well?
At this point, the individual permits will be based on the pressure at the individual well. The point 2 is our administratively approved. So that's the administrative limitation that we're placing on. Now, the opportunity of a step rate test in front of that will give us a greater level of understanding of what the formation or defect of what the conditions in the reservoir are. We normally look at that maximum volume injection as a best estimate, and not necessarily a permit condition. But under our rules currently, the pressure, the maximum surface injection pressure is what decides the volume going down.
So the commission doesn't need to be worried about the current volume.
No, I think what we tend to see is that it's the best guess for the situation because we don't know what they're going to encounter downhole. And certainly not all drillers are good.
So you talked about there are some few fractures that based on previous statements has been discovered in the DMG. Now, but if you look at the exhibit 11, I don't see any tool that you have in there. And so number 4, for example, in terms of the testing and monitoring procedures, I know Chevron is going to deploy FMI. Definitely they're going to use that to prove that there are no fractures here and there. So is NMOC they're going to consider if fractures is a problem, put in, let's say, a tube like FMI to also get it?
We would certainly adopt that with no problems.
Okay.
Our position is that we have to go to industry And with regards to operators such as Chevron or Newborn, they're willing to make the investment. Our problem will be going to those applicants who will not be interested in that type of thing. And so if the commission sees that, the more information we have, certainly the better way we can characterize and make a decision.
So that is something that commission can also add to.
Yes, you may add as many things as you wish.
You made mention of, let's say, once we approve this application, there's going to be a volume of applications coming through.
Correct.
Yeah, I'm sure probably the same thing applies to the AGI wells, where when you started approving, there are a lot of flood of applications coming through. And then there, you added modeling to it. Yeah, so I'm a little bit concerned about, let's say, presenting these complex projects, and then a lot of different projects coming through without really thinking about what to take into consideration the past operations, to help us to more or less look into the future. So is this something that an MOCD is looking at, or probably not at this time?
And that's why we're probably going to have to solicit outside sources. For instance, you've heard of Scissors and their support of the seismic issues and putting together a cooperative. I don't imagine us being that good to be modelers and experts in that. So yes, we will have to seek a support mechanism in that sense.
Well, so you do have that support some way somehow, because you do have, so you normally use NMOs, you use Bureau of Geology for most of your geological work. Why not use PRC for some of the modeling work? Because that's what we do.
Yeah, no, I mean, there's a variety of sources, and what we would do is probably look for something in the educational system, whether we will say UNM, but yeah, things along. But yes, we have, and this is something we've lost over the years. We used to use the Bureau for more information, especially in the early years of oil and gas development. We only have recently returned, especially when we saw the information coming in with Devonian logging. For us to know if the permitted interval was really what was being injected into, we had to have a third party, in this case, the group at the Bureau, come in and map for us what is truly being seen on the logs. And therefore, our side for the compliance issue of saying, yes, they are completed in that interval is satisfied. And also, because we had very limited information, again, going to a third party to compile that information and using it as a basis for our decisions is going to be critical. We do the same thing with seismic. We're not seismologists, and certainly we regard industry's input as important and rely upon them to give us better information and understanding of the modeling complex. So it's not just going to be us in the back room looking at models and saying yes or no. It'll be in a relationship. But again, this brings us to the other consideration. If I have an application from a ma and pa operation, then we're going to see this thing of, well, you're denying us a business. And I don't see that being much of an issue, but I do see that we're going to have more cooperation and better understanding, especially when modeling coming in. We're going to need some assistance.
You made mention about the way Chevron presented the application in such a way that the Lamar and then also the lower formation is a little bit of a problem. But I want a clarification though, because shouldn't the system be treated as, let's say, a storage complex where they have to clarify where their confining zones are? And I think that is what they did. So I was a little bit confused. So if you could clarify that.
Under the UIC rules, what you're asking for is an interval for injection into. So realistically, it would be from the base, let's say, for reasons of discussion, the base of the Lamar to some sort of impermeable barrier that they identify in the upper brush. The confining layers are not included in the injection interval. And so when we write that permit, we say that that's the injection interval. And then we have the rule that says if it gets out, we say it has to stay in that injection interval. Once it gets out of it, then you're in violation of that permit condition, and then we have to revisit it. So our compliance is that, okay, you're inside that interval, fine. But if, in certain cases, I had a well that was in the southeast, DMG. It went down to the top of the brushy. We ran a spinner on it, and 99% of the fluid was going in the bottom 50 feet of a 700-foot well. So we know there it's going below what was permitted. And then we have to revisit those people and say, either this permit's got to go, or you got to show us you're not impacting the outside of your confining layer.
Okay. Okay. Let's see. I think I'll end here. Thank you.
I had a few more introductory on FOMA.
I want Phil to talk to me. So.
Thank you, Mr. Guest, for your testimony today. Quite sure where to begin here, but let's at least go to Exhibit 11 2C, the criteria for selection of injection interval. We see here the application should include a review of the AOR, assessment for evidence of natural fracture systems or faults. I'm not familiar with the C108. Is there a specified distance or radius, the AOR, or is that something that you negotiate with the applicant, Mr. Guest?
Under our primacy agreement, all states have to declare there are two ways of doing it. Either it's a static distance area review, or there's a formula. And remembering that UIC rules are applied throughout the United States, whatever fits your program best is what's selected. The division chose to go with a stagnant 1/2 mile radius of review. And it has been successful up till now. One of the reasons we had gone to hearing with the Devonian wells was because of the fact we felt that it was going to exceed that 1/2 mile. It has been, shall we say, through usage, used as a type of spacing. Typically, what happens is that if someone has an SWD within that 1/2 mile radius, it ends up being a protested application. So it has been a matter of convenience to exclude any other disposal actions that are in the same interval in that 1/2 mile AOR.
Jump around a little bit. The OCD in its pre-hearing statement said that, quote, OCD neither supports nor opposes the applications with the current knowledge of the DMG for the selected locations, but would require any UIC permits to incorporate the additional conditions provided in Exhibit 11. Are you, Mr. Guest, comfortable with the 2 mile AOR here?
We'll take as much distance as we can get. I think it's frugal. Will it stand? We'll find out. I mean, that's one of the reasons of doing the testing. It may be in some areas, if you want to utilize the Delaware Mountain Group in that area, that will be a necessity. But there may be areas where the rock and the formation, again, looking at the Nance paper and the uniqueness of the deposition, there might be areas where closer is practical and acceptable if the information supports that.
Thank you. Dr. Napoma asked a little bit about where this heads, what the process looks like for subsequent applicants for the DMG. I know I might be getting into OCD territory a little bit here, but it helps me think about how we deal with the case in front of us. In the long term, do you see a special C-108 application for the DMG, or how does that, how do you envision that?
I know, I see a change in the 108 entirely if you're going to do disposal. I think the fact that we have something that dates back to 2000 and does not represent current status of the necessity for disposal and making sure that it happens right. We've always been light on the requirements. But we are seeing the demand that we know more about it in order for us to issue a permit in that process.
I believe I reviewed everything with all the materials that were presented to us, and trying to reflect on what we've heard since yesterday. It feels like a long time ago that we began. A little unclear how we wind this up today, or where we go, and I don't know if you can speak to that, or if it's some combination of maybe OCD and Chevron speaking to this, or if our chair would have thoughts. But are we looking for an order here at the end, or an instruction to the OCD to evaluate? I don't know if you have any thoughts on this. We're asking the right person to use. So.
I think you can go either way. I think giving us direction to approve what they provided and do it through a permit that the director signs on behalf of the commission is a possibility. We would use our standard template plus whatever you put into the conditions of the order, and then stipulate, 2 years, come back, talk to us, and tell us how it's working. I think that's practical, and I think also gives us the opportunity to, if we're going to again do administratively, that gives us the opportunity to figure out what the language should look like. Does that mean we have to provide you an example of what we're going to issue? That would be up to you. You want to see what the final order looks like, and tell us to write one and take whatever they want to put in and whatever we want to put in. And I think we can negotiate something and then provide a result.
Would OCD be okay if it should be okay if we asked it, if Chevron and OCD came back at the end of the first year of operations and asked for a report?
Oh, sure. I mean, if you want to increase the frequency, the better it is for us.
And perhaps do every couple of years after that. It looks good.
Because again, remember, you're going to be giving us a guidance that we will take, pluck out and put it in another permit. So we've been forewarned that permits are at the gate. The better, the faster, and the more consistent we have it up front, certainly we'll be in a better position. And especially since you folks are going to be involved, you'll be able to see that information also.
What I was thinking about. Okay, I appreciate that. Don't believe I have any further questions.
I would not forget Mr. Nino.
I think he's listening in today, so thank you. No further questions at this time. Thank you.
I have no additional questions for the witness, then we're covered. So unless there's redirect, Mr. Getz, you are excused.
No, it's fine.
One more.
Oh, you didn't get up fast enough, Mr. Getz.
What about this one? So Chevron showed a plot of how much water is actually being produced, compared to how much is actually injected into Mexico. That is really an alarming plot, because it sounds like you have a lot of water that we are more or less pushing to Texas. So what is NMOCD really doing about this?
Well, now you're getting into state politics.
Oh, no.
I mean, this is one of the problems of considering the Permian Basin is between two states with two set of rules that are different. So limitations that we have, for instance, we have the waste isolation pilot. Having injection around there with the Delaware Mountain Group, we've kind of gotten away from it because the Department of Energy doesn't want to see it. The ongoing consideration that, yes, a lot of the operators are sending water to Texas because of the fact that DMG injection is quite favorable now, because they are not restricted by correlative rights. They're not restricted by what we have as limitations on injection pressure. And so there will be at some point, and there already has been in the Texas legislature, to put a surcharge on water coming from New Mexico in the hopes that it stays here. So yes, there will be a push for shallow injection, and it will be coming to our doorstep fast, because that is growing that distance between disposal and what is out there and needs to be disposed of. The capacity versus what's being produced is still expanding. But then again, this is where we're looking at multiple, though the Devonian has had its issues and it does have limitations. And this is one of the papers that was done by Dr. Scanlon with the Bureau of Economic Geology, is that OCD is going to have to look at this as a whole basin issue. And it's going to be the operators cooperating, or they are willing to cooperate, and work together to have multiple sources of disposal. So, I mean, there are areas of looking at breaking up this disposal and still meeting the capacity. But the biggest problem gets to be is that historically we've all run to the same location at the same time. And as a result, we've ended up with problems. And to point out that this is not the only issue here. In Raton, we have coal bed methane, we have inducing seismicity up there, and all that water is coming from Colorado. So our neighbors share a lot with us.
Thank you, sir.
Thank you. You are now excused.
I'm
Yes.
Thank you.
Mr. Tremaine, do you have another witness?
We do, OCD would call, Mr. Million, Governor Recap.
And I would just state, unless there are objections here, Mr. Gabriel McCall has appeared before the commission this year, accepted as an expert and other things. Unless there are concerns about his qualifications, or you are offering him for a different purpose than he was previously qualified, I'd propose that we just allow him to testify without a customary kind of background introduction, if parties are comfortable.
Totally comfortable with that.
Yep.
Thank you.
Mr. Gabriel, may I ask the court reporter to swear the witness in?
Please raise your right hand. Do you swear or affirm that the testimony you give today will be the truth, the whole truth, and nothing but the truth?
I do.
Please have a seat, sir. You.
Good morning, almost afternoon now. Mr.
Afternoon,
Million.
yeah.
Could you please state your name for the record?
Yeah, my name is Million Gabriel Michael.
What is your current position with the Oil Conservation Division?
Well, I'm a petroleum specialist advanced with NMOCD for the underground injection control group.
I'm going to skip here noting the commission's acceptance of Mr. Gabriel Michael as an expert in the areas of petroleum engineering and underground injection. And move exhibit OCD number 3, which is the curriculum vitae of Mr. Gabriel Michael.
Any objection?
No.
Accept, admitted.
All right, skipping over education and experience. Mr. Gabriel Michael, please provide a brief summary of your testimony today.
My testimony today will be focusing on Exhibit 12 and then also Exhibit 11, item number 4. I'll explain or answer any questions in regard to the conditionals of approvals that we're putting in regard to the well testing, like the step rate test, which is commonly known as SRT, or follow-up test in order to determine the right maximum allowable surface injection pressure. Also, once they commence injection, also monitoring the well in order to make sure that the inject state or the fluid injected stays within the intended zone, so they don't infringe upon the correlative rights.
Mr. Gabriel Michael, have you reviewed the applications submitted by Chevron in the cases today?
Yes.
And when you review the applications for saltwater disposal wells at a general level, what are you reviewing for?
Generally, what I review is the administrative completeness of the application. And then we do a technical review of geological and then engineering standards to ensure protection of the corroborative rights, prevention of waste, and protecting the environment.
And you mentioned OCD exhibits 11, which has been admitted, and OCD exhibit 12, which we'll talk about momentarily. Are you familiar with and participate in the recommendations included in those exhibits?
Yes.
And at a summary level, is it your professional opinion that you support these conditions of approval and that they're necessary for the protection of relative rights and prevention of waste?
Yes.
Specifically, I'd like to direct you to exhibit number 12, which is up on the screen right now. Does this exhibit show OCD's proposal for step rate test guidelines?
Yes, it does.
And why does OCD require a permittee to conduct?
Mr. Tremaine, sorry for the introduction. Can you have the witness or can the witness clarify, was this guidance developed specifically in response to this application, or is this a standard guidance provided for these types of tests by OCD?
This is the standard guidance for all the SWD wells.
Thank you. Mr. Gebremichael, why, in general application, when do SRT tests occur for SWDs?
Well, generally, NMOCD requires an SRT when the well already commenced injection. After building up some kind of pressure, they would apply for what we call IPI, increase for injection pressure increase. Then we would require them to conduct an SRT. And then based on the result of the SRT, whatever that pressure gradient that we got with some application of some safety factors, and then we would allow them, we would award them with the new maximum allowed surface injection pressure.
Okay. So to clarify on the chair's questions, this guidance is a general applicability, and generally speaking, SRTs are required by OCD after injections commenced and when certain changes are made to the well.
Exactly.
Okay. In this specific case, is it true that OCD is recommending commencement of an SRT test prior to commencement of injection?
Yes.
Okay. So while this exhibit 12 is generally applicable, OCD is recommending, based on the facts of this case, that SRTs are required prior to commencement of injection. So it's an additional requirement beyond what's discussed in the document.
That's true.
Okay, thank you for that clarification. So why specifically does OCD recommend requiring Chevron to conduct an SRT on the injection interval formation prior to commencing injection?
Well, the reason is given the historical occurrence of infringement or impairing of corroborative rights in the DMG zone, OCD believes that having conducting SRT prior to commencement of injection would give us a good picture on the parting pressure, and then with application of some safety factors. So we are on a good start that we are applying the right maximum allowable surface injection pressure that would contribute to protecting corroborative rights.
Can you explain to the commission how you referenced this at a general level previously, but how the information that's gathered from a step rate test is used to set or change permitted injection pressure?
Yes. So generally speaking, OCD administratively, we award operators or permittees the 0.22 PSI per gradient. But in this case, DMG, like I stated before, given the heterogeneity nature of or complexity nature of the reservoir, and then past occurrence of infringement of corroborative rights, having that prior knowledge would contribute to or assigning that pressure before they commence injection would help us to assign, okay, this is what your maximum allowable pressure is going to be with application of safety factor. When we talk about safety factor, it could be 5%, it could be 10% based, what kind of tubing size they are using, what type of tubing length they are using, or the permeability of the reservoir. Based on those, kind of friction loss involved, we could award them the right maximum allowable pressure. And then in that case, that makes us confident that, the chloride right is, protected. Also, from Chevron's presentation, I learned that DFID, or some other places they call it a mini frac test, collaborating both the SRT test result, the mini frac test result, that would put us in a good position to assign the right maximum allowable surface injection pressure.
So despite the fact that administratively OCD would typically approve a 0.2 injection, max injection pressure, and depart from that based on an SRT, because of the issues of identified history of interference and the heterogeneity of the injection zone. In this case, is it true that OCD would be getting that information up front and then would reassess that maximum injection pressure based on that test?
That's true.
One moment.
Yeah.
Mr. Geber-Michael, we jumped in my questions here, so I just want to make sure, I think we've covered everything. Is there anything that is pertinent to the step rate test and the guidelines as applied to these cases that you think that the commission needs to know?
Yes, for instance, the two subject wells, we're looking, they are injecting both in Bell and Cherry canyons. They are injecting both simultaneously in those formations. When we see the SRT plot, we would see an early deflection point. The reason is because they are testing them both at the same time. Some operators, they may inject on maybe just Bell formation or a Cherry formation, but lately we've been seeing that the permits are coming for both. In that case, OCD recommends to put a testing plot separating those two formations and then testing them separately. In that case, we have two separate fracture gradients. And then usually we're going to go with the weakest link. The lowest fracture gradient will govern the surface injection pressure for both formations. In this case, probably that's what unique about the SRT case that I want to bring to attention to the commission. Yeah.
Okay. I want to, we have exhibit 12 up here as the standard in reference to that, but I want to refer back to OCD exhibit number 11.
I can forward you.
And on the second page of that, which is page 158, and specifically ask you about this fall plot.
Yes.
Can you explain the basis, what information OCD is looking for with this fall plot, and how does that interrelate with the information that we're discussing with the SRTs and the other tests?
Yes. Well, the pulse plot is one of the engineering tools that we can utilize to have an early warning of if the injectate is, there's any indication flowing out of the intended zone. So with this, the early warning I say is in the past, when you have the infringement, you see it on the offsetting well, an increase in water gap. By that time, the reservoir is already destroyed, yet compromised, exactly. But with this one, what we require, like Chevron, maybe future applicants is, the Hall's plot is very easy to construct. And then once you construct it, even with the SCADA and others, there's a live data that's coming in. Once it's constructed, it could be automatically tell you, any deviation from the, there are 3-4 lines in the Hall's plot, but I'm going to focus, the one that depicts the outward zone injection. And then when we see that, and then they could inform OCD, and then we could take appropriate measures. It could be curtailment of production, and then it could be even total shutting of the well. So we believe that having a good Hall's plot will help us determining early enough before the infringement of core rights.
So in summary, the purpose of the SRT requirement prior to commencement of injection is to inform OCD's knowledge of formation parting pressure and appropriate max injection PSI. Right. And the purpose of the Hall plot is to help identify any issues or to isolate issues between the two different proposed injection zones.
No, like, the Hall's plot is applied even in any water flooding and all this. So the Hall's plot is basically going to tell us is, in the entire injection zone, if we have any deviation, leaving out of this intended zone, it's going to tell us. But what I have seen is more even empirical data is Chevron has provided a hydrologic modeling, right? That would even give us how, the injectate is migrating over time. We can collaborate all those evidence to come up. The main goal here is, to tame it before it compromises the reservoir. Because once, you see an increase in water path, right? Okay, maybe that operator is not happy with that, but as far as protecting west, the reservoir is already compromised. So these are early warning or early detection tools.
Okay. Well, that was my takeaway here was that the combination, it's true that the combination of monitoring and testing and reporting that Chevron's proposed, along with the OCD's requirement for the SRT test specifically prior to commencement injection and Hall's plot, together will put OCD in a position where you can identify, or you may be able to identify potential impacts to the resource prior to when they occur.
Exactly.
And last question, Mr. Governor Michael, in your opinion, are the conditions and SRT proposals in OCD exhibits 11 and 12 necessary to prevent waste and protect relevant rights?
Yes.
No further questions?
The exhibits to introduce before we.
Yes. If I could, Chair, could I please move admission of exhibit 12?
Any objection? Accepted. Ms. Bennett, with yours across.
Thank you. Nice to meet you.
Same here.
I just had a couple of quick questions. As you might have heard from my earlier questioning yesterday, Chevron does have some questions or desire to collaborate with the division on the step rate test methodology. And in particular, it sounds like to me from your testimony just now that there is some flexibility there, especially with respect to the pre-injection or prior to the SRT that you're envisioning prior to commencement of injection. Did I hear that correctly, that there's some
Flexibility in what term?
Well, what Chevron's goal would be is to be able to submit an SRT plan to the division for both wells, and then work collaboratively with the division to ensure that that plan meets your requirements, but also allows for the unique circumstances that we're faced with today.
That's true.
Okay. I think that's the only question I have.
No, that's great.
Thank you.
You're very welcome.
Ms. Hardy, do you have any questions?
Just a couple. Hello, Mr. Carmichael. Just have a couple of questions for you.
Absolutely.
Can you please clarify what criteria you are going to use to determine whether a 5% or 10% safety factor will be applied to the step rate test results?
Yes. Well, like I mentioned earlier, it depends, how much of the pressure friction loss is, right? So if there is a huge friction loss, when it makes it down to the bottom, then we tend to compensate for that friction loss by instead of going 10%, maybe go 5% of that safety factor. Also, permeability also plays a role here, right? When you have very tight permeability, probably new wall friction could be higher than the tubing friction. In that case, we see the whole picture in awarding whether to go with 5% or 10%. Yeah, because our goal is at the end of the day is how much of pressure is impacting that rock. That's what we are concerned most of the time. As far as the optimization of the injection step, it's the role of the production or injection engineer, making sure to reduce the friction loss.
Thank you. One more question. Can you please clarify if an operator is planning a Bell Canyon or Cherry Canyon SWT completion and decides not to perform a combined layer step rate test, but decides to perform individual layer defits, what defit parting pressure are you going to utilize to determine the max injection?
That's a very good question. See, as we go along with the DMG, the more data we gather, and then our goal is at one point to establish a regional fracture gradient for the DMG. So do we use SRT or do we use the mini frac test? In my opinion, the mini frac test is more reliable. But at this time, though, what we're going to do is collaborate, both compare and contrast. And then from a division perspective, always go with the lowest one.
Those are all my questions. Thank you very much.
Dr. Mboma?
Yeah, thank you so much for the testimony. For clarification though, so I also had a question on the safety factor.
Yes.
Right, so I do know that normally EPA will say 10% safety factor. So do you know anywhere where they've been flexible on the safety factor? Some examples?
Well, I'm comparing to other jurisdictions, they apply 5% at 10%, but you're right, 10% has been the usual one, but if you have a huge frictional loss, it should be left to the discretion of the OCD. Yes, and then, for instance, in this case, they are using a 5.5-inch tubing in tandem with that permeability. Correct me if I'm wrong. Is it 0.03 MD? Yeah, there's something in there. So in that case, we expect that applying at 10% is a safe way to go.
Okay.
Yeah.
Okay. So let's clarify a little bit. So yesterday there was a distinction between defect and manufacturing. And I remember Tom from Chevron was saying that he had a higher confidence in defect compared to mini-frac. So in your exhibit number 12, the second part.
Sorry, is there a difference between mini frac and defect?
Oh, yeah. Yeah. You're not going to, yeah. He was allowed.
Yeah.
Yeah.
The witness is sworn, you were sworn in yesterday, so obligations to apply, but yes, please come up.
Normally, a mini frac is run open hole with an MDT tool.
The witness, come to the mic, please.
Can you come to the mic, please?
Can you hear me now?
Yeah, you should be good there.
That's great, thank you.
Normally, a mini frac is run open hole with an MDT tool or an RDT tool. And so Packer's engaged against the actual reservoir.
Okay.
And so one of the challenges under that situation is, it's more economical, it's faster, but the reliability or the chance of getting good data and no leakage in the packer, because you're up against the reservoir, is less. Now, it tells you the same type of data. It gives you, it's an injection test. Usually the advantage is it's over a little bit longer interval than with a defit, because a defit is really through one perforation through casing. But the reason why we wanted to go with defits, still it's an injection test, was that if we run it, we have a 95% chance of getting good data. With a mini frac, from our experience with our SMEs, it's down around 40%. And if we're going to spend the time and effort, we want to make sure we get good data.
No, that's great.
And that's the reason why we're.
Yeah. The only question I have on this one is, given the your interval zone, right, between the top and then the bottom perforation is around 4,000 feet. Is that right? And there's 2 wells.
It's a little bit shallower than this is Severitas.
And Severitas is around 3,000 something, and then Papa Squirrel is around 4,000. So the only concern that I have is such a long interval. Are you confident carrying out the defeat?
We're going to take, so the purpose, what I think the OCD and the commissioner kind of struggling with right now is how are we actually going to use the defense?
Well, I'm not struggling with it.
Okay.
Because I have a concern about using a mini frac, right? So I just want to clarify whether mini frac is still meaning defect, or let's say either you can use either of them.
You can use either one, and all we're saying is we want to go with the defib. We prefer to go with the defib case total.
Yeah, but
because of the reliability of the chance of success of getting good data, it's higher.
I brought that up because let's say the way it is read, it's more like you have to perform mini frac. Now, like you're saying, what about if the whole condition doesn't allow you to perform mini frac? So then you have no choice but to go for defib. Right. So
right, and we basically have opted to not even attempt MDT any frac.
Okay.
We're wanting specifically, when we say defib, we mean defib.
yeah, so I do have a concern with the exhibit wall, how it is presented to us now. So even MOCD might want to look at it.
Mr. Tremaine.
Just a point of order. I just want to make sure that we're preserving a very clear record, Mr. Chair. And so if you want to, if the commissioners want to ask witnesses questions out of order, no objection to that whatsoever. I do ask to limit discussion between the witnesses, just for clarity of the record. And Mr. Michael can answer questions directly back to the commission. That's just, I just want to make sure that we're very clear and with people. The commissioner's question is completely appropriate, and I think OCD is very willing to consider revision of 12. This is general. This is information for the commission. This is a proposal for general application, and I think the feedback on DFID versus mini frac is something that OCD is definitely interested in, and I'll let Mr. Gabriel will respond to that directly.
Okay, so another question. I thought that a separate test is going to be done, per zone, right? Let's say, or do you think, or let's say it's going to be done entirely? So I just want to know how the Chevron application is, because.
Well, they haven't specified that yet.
Oh, then let's talk about that.
Yes, that's what I mentioned is in the past, some operators, they did step rate test for both zones, right? What we have seen in that step rate graph, the pressure versus rate is you get an early deflection and then a second deflection. So most probably still we're in the data gathering mode, right? And then this is our recommendation. If you tested them separately, you get 2 deflection points, separate graphs. And then the lowest one is gonna dictate or govern what the maximum surface injection pressure is gonna be.
So just to be clear, that NMOCD is going to insist, or let's say more like discuss with an operator, that you prefer them doing the separate test.
Separately.
Separately.
Yes.
Commissioner Mpomo, I think I would clarify here, that may be something for us to provide guidance on in response to the application. Of just, we can discuss in deliberations, but I think there are some questions here about how we.
Yeah, I was more like clarifying.
Yeah.
Because the way he presented it, I thought that was what was in the application. But
No.
so
no.
I just.
Like I said, each well is due to heterogeneity of the reservoir, right? You have to take it case by case. In this case, what I have seen is both the Bell and Cherry, they are the injection zones, right? And then they are. So by doing that, it will help us testing them separately to determine the right maximum allowable surface injection pressure.
I have a last question. So you made reference to Chevron's RTA analysis that they did, where it was showing that we can see the movement of the injected water.
The model.
Of the model. Do you feel that homogeneous model is adequate, to fully understand the movement of the water?
I'm not in a position to say, I'm not an expert in hydrology modeling and stuff, but you can collaborate, with the other data that you have, like the SRT, Hall's plot, and then this model, and then it tells us the path of the injectate, so that's
So it
how
could still be adequate, combined with that other.
Yes.
data.
Yes.
Okay, thank you.
Commissioner Bloom?
I have no questions. Thank you. You get your time.
No questions from me either. Any redirect? The witness is excused. Mr. Tremaine, do you have any more witnesses?
No further witnesses.
Thank you.
I think we'll allow for some brief closing remarks from the parties, starting with Chevron, OCD, and then counsel from Mewbourne. If you have any closing comments.
Thank you. I just have a few closing comments and then a potential item offer to coordinate with Mr. Tremaine. Myself and Chevron both appreciate the commission's time and the thoughtfulness that went into this hearing. I personally feel like we discussed a number of very important issues with the commissioners and with the OCD witnesses, and also through the Mewbourne question. So really appreciate the commissioner's time and also the willingness to sort of put us on a trailing docket that worked out well for everyone, I think. So definitely appreciate your coordination and collaboration on these hearings and the thoughtful questions that were asked today. My takeaway from the different discussions that we've had is that everyone acknowledges the need for additional disposal options in New Mexico. And I'm reminded of a slogan from a couple of administrations ago about all of the above. And that's what I feel like we're talking about here today, is that the DMG disposal is an important component of all of the above disposal options that are available to the division and available to New Mexico and available to operators. And the evidence that Chevron put on today, as well as the evidence from the OCD, reflects that DMG disposal can be done in a way that protects relative rights and prevents waste. And that's also protective of underground sources of drinking water. And so the evidence today and yesterday, I believe it shows the viability of these pilot projects. And when you combine that with Chevron's diligence and its desire to do data collection and its desire to be transparent with that data collection, this seems like a win-win for the division, for the commission, for New Mexico, in addition to Chevron, of course. But it allows the ability of Chevron to manage the producers and the disposal wells here, I think, is key for the pilot project, as is the notion of selecting 2 different wells for the pilot project with different geology and different in turn different porosity and different characteristics that Chevron is committed to reviewing, monitoring, and then providing the data to the division and to other stakeholders. So again, we really appreciate the commission's time. I understand Commissioner Bloom's question about next steps. And I would like to coordinate with Mr. Tremaine and Ms. Hardy on next steps that might be helpful for the commission, including, as Mr. Getz suggested, submitting an order or proposed form of order that the parties work on together for the commission's review. But of course, that's something that I would leave to the commission to decide whether that would be helpful, and then also to coordinate with other members, other council and other parties here about the process to move that forward. I do know that the commission has a very busy schedule coming up between the legislative session and then the PFAS rulemaking. And Chevron appreciates the time that we were able to spend today, and so is hopeful that there isn't a huge lapse of time between now and the time that we can get some have some further guidance from the commission. And so we're just recognizing that I am here committing my full efforts to whatever I can do on Chevron's behalf to move this forward. Thank you very much.
Thank you. Mr. Tremaine?
Mr. Chair, Commissioners, thank you for this opportunity. I think the hearing kind of made clear, and OCD has expressed really kind of three overriding concerns here. There's a recognition that there's a truly significant need for additional disposal. OCD recognizes that the water disposal disparities and plots. There's also quite a bit of uncertainty related to certain aspects of the geological information that's necessary for OCD approval. And that drives OCD's requests or determinations that additional information is necessary in terms of the applications, whether they're before this commission or whether they're approved administratively. And that DMG disposal, despite the assurances and everything that we've heard during this hearing, does represent a potentially significant potential for interference if something goes wrong. So those safeguards are truly necessary. I think that I'd like to address a couple items on Exhibit 11. We talked about that quite a bit. And I want to clarify for the commission that Exhibit 11 is an internal administrative review document that these conditions, they're not set in stone, first of all. But as a snapshot in time, this is what the division feels is necessary and appropriate, given OCD's existing authority and the fact patterns surrounding information available regarding the Delaware Mountain Group generally. So there's been a lot of discussion about what needs to be approved by the commission and what is being put forth by the division. I think that's appropriate, entirely respectful, but I think it is necessary to push a little farther and say that the recommendations that are put forth in OCD Exhibits 11 and 12, I think I want to make clear for the record that those are appropriate under existing authorities, right? This isn't, these cases before the commission require this particular type of approval. So this is not a new set of requirements that OCD is presenting to the commission. These are, as I said, appropriate and consistent with OCD's generalized authority and testing authorities under both statute and the rules. So these are general plans that are provided for information. In terms of what the division does with those in this case, I think it is not strictly necessary that the commission adopt those as a general guideline. I think that the ask specifically is that the commission adopt those as a floor specific to cases 2, 3, 6, 8, 6, and 7. And so while they're provided as general information, they're adopted specific to the facts of these cases, along with the other specific modifications that we've discussed above and beyond what's contained in those exhibits. So I wanted to clarify that what we're doing here, what the ask is ultimately. And I do share, I think there's been a lot of good discussion back and forth prior to this hearing, during this hearing, about what's appropriate, and it seems that the puppies are close. There's some details to hammer out, some clarifications about SRTs and reason defects, et cetera. And I think that despite what I said, obviously this commission has authority to modify those based on the information provided, but it seems like it would be the best, most efficient course of action if the parties work together on a proposed order, and if there was something that needed to be modified in that the commission could certainly do so.
Ms. Hardy? Thank you, Mr. Tremaine.
Thank you, and I'll be brief. I'd like to thank the commission for its time and hearing all the testimony and giving thoughtful consideration to these issues that have potentially serious implications. Newborn, again, does not oppose Chevron's applications as long as appropriate conditions are imposed on the injection and appropriate monitoring occurs to ensure protection of correlative rights. And in that regard, we support OCD's proposed conditions on these permits. So thank you very much.
Thank you. Thank you, everyone. That was a very informative presentation. Unless my fellow commissioners feel it's necessary, I think we can just deliberate in public setting and then we can close it. And I might kick off with some observations and then turn it over to my commissioners. I 100% agree with the statements that, managing produced water is an ongoing challenge and something we need to look at, and optionality is important. At least from where I sit, I'm not sure DMG disposal is the panacea that fixes it all. I still think you're truly going to need all of the above, which included some deep disposal. And certainly the remarks, the sort of written concluding remarks that sort of Chevron put in a record just reacting to it. Yes, deep disposal is contributing to seismicity, but also an ongoing discussion. It doesn't contribute to seismicity everywhere. And so there are some other questions. I really do think it's a component. We do have I think we need to be careful. We do have correlative rights. So looking across the border into Texas is not a great model for us because we do have an obligation to protect correlative rights and present waste. So I think it's appropriate that we sort of take these steps carefully. But I think that's why it's important to begin looking at a pilot project at the edge of the exclusion zone. I would say, at least in my observation, the evidence offered in the record maybe doesn't go so far as to say that disposal can be done in the Avalon exclusion zone writ large. But I think Chevron has demonstrated today that their proposed disposal at the two wells, at least from where I'm sitting, can be done within the portion of the Avalon exclusion zone that Chevron's operating in. And I say sort of approaching this with caution, maybe as more of a message to others who might be looking to pursue this. We're going to do this deliberately, or I think we should be doing this deliberately. I think we should be providing guidance to OCD that enables to do facets of it administratively. Most saltwater disposal wells don't actually come to the commission because a lot of them are handled administratively or at division hearings. But I think it's incumbent upon the commission to provide some guidance about how that's done, and sort of what the pieces are like. And I guess I'd lastly say, my fellow commissioner, Dr. Mpoma, asked some questions about water and the water delta and water graph. I mean, unfortunately, we did it to ourselves. The state, in its wisdom, decided to start getting better data on produced water, where it goes, volumes, and other pieces. We know. Also state for the record, to the extent the Texas Railroad Commission watches this, they take loads of water from Louisiana. I've heard almost all of it. They take loads of water from Oklahoma, and there currently, except until real recently, isn't a lot of good data on it. So New Mexico, we've got a good handle on the problem and sort of what are the pieces. I think that's why it's incumbent upon us to begin thinking about ways to address it. And I guess my last thought here, I think in the back and forth, Dr. Mpoma also asked, what are we deciding on? What are the pieces? I think there are two things. I think offering some observations, and I'm not sure it's a blessing or an approval on OCD's Exhibit 11, which is sort of the standard rules of the road. Here's what we're thinking about administratively is important, at least providing some, we're comfortable with this list. I'm not sure we're there based on the questions and sort of feedback. And then I think there are the specific applications before us. And I guess I'd close with this. At some levels, this strikes as an application that can be permitted using OCD standard templates, and we're talking about special conditions that are attached to it. Aspects of Exhibit 11 don't exactly trace over onto that permit because, well, for example, we are in the Avalon exclusion zone. But I think where we are, at least where I am, is that this case gets continued, and I'm willing to continue it shortly for the parties to come together and put together an order using OCD's established templates that has appropriate special conditions in it in light of the testimony that we received. At least on my end, I would flag, and this is maybe something specific. I'm going to pull up the exhibit numbers. Bear with me 1 second. I had them and then I flipped to another. Does Chevron happen to know the exhibits where they showed the maximum rates and the volumes, and it was like different colors and years out? Do you know the page number? Oh yeah, I found it. One, in putting those together, at least from where the chair sits, I think at the sort of injection rate, the maximum injection rate, I believe that's a condition in our standard permit template. I see for Popper Squirrel, the modeling does show it theoretically maybe gets up to 20,000, so that's something there. The Severitas is sort of notably below the 15,000. So when thinking about how you're developing a permit for that well, maybe sort of align it a little better with your modeling. I'm sensitive to the testimony of Mr. Getz that we'd authorize these daily limits that would never, ever, ever be reached, but sort of theoretically as you're, managing reservoirs, it's a question, but put it on the parties to come back with sort of an order package that follows the OCD's standard permit template, is an order issued by the commission with special conditions that I think track the testimony and feedback here. I think that's one element. I would also encourage at the same time, because I heard from the OCD that you are looking for at least some commission guidance and other pieces, that Exhibit 11, those elements that are appropriate for the specific cases Chevron's had be incorporated in, but that there also be an updated Exhibit 11 that reflects some of the feedback and questions you heard. Again, not clear that as a sort of generalized guidance document that is something that, at least from where I'm sitting, the commission needs to approve, but it is something we could provide some guidance on. And I think as submitted, there were certainly some feedback from my fellow commissioners that I think should be incorporated before we opine on it. So those are my observations. Commissioner Bloom?
Sure. Thank you, Mr. Chair. Yes, I would agree that as we're here working to protect correlative rights, prevent waste, and also protecting health and the environment, that all that includes proper water management. And I see the parties working together to prepare for the OCC a draft order that includes what we heard the past 2 days from Chevron and the OCD, and using OCD's exhibits 11 and 12 to inform a draft order for these two cases. Thank you all for your time and presentations. 2 days, appreciate it.
Okay.
Commissioner Poma?
Yeah, so Chair, it sounds like you summarized this in more detail, in terms of what we had for the 2 days, and then also the next steps. And I do appreciate the hard work that Chevron did. This was really comprehensive presentation. I do appreciate that compared to, let's say, what some of the presentations I've seen on SWDs. This is really comprehensive. So I do appreciate that. And I do also support that the parties should come together, work on the order with the conditions for the commission's approval or at least review. And I'm sure we've made mention of quite a number of issues, and we hope that the parties will take that into consideration in drafting the order. Thank you.
So I suppose hearing that discussion, I would propose we move to continue this case to the next scheduled meeting for the parties to make an attempt to provide an order and then independently an updated Exhibit 11. Obviously, like all things moving on the docket, things can adjust based on how those discussions are going. But I think in sensitive to the need to start developing some of these disposal options of continuance to the next meeting is an appropriate step. So if I can get a second on a motion to continue this case to the next meeting for preparation or presentation to the commission of a draft order and an updated exhibit 11.
Second.
Dr. Mpoma, how do you vote? Approved. Dr. Bloom?
Approved.
Let the record reflect that a motion was adopted unanimously. And there were no other active items on the agenda. Obviously, we had pending litigation, just noted it was there, but there was no substantive update. It's just noting that the case remains pending. Are there any other items for the Oil Conservation Commission?
Mr. Chair, I believe there was an update on the Atencio case if you.
Sorry, go for it.
So there was no update on the Atencio case other than to say that the response to the motion for judgment on the pleadings is due the 21st of this month. So we will have.
Oh.
So I don't know if we'll.
Do we anticipate additional briefing or not too early to tell?
Well, there'll certainly be a reply.
Okay.
And so far we had OCC and the EIB. We joined in the motion on the pleadings.
Okay.
As to whether we will have to go line by line and admit or deny the allegations in that 500 paragraph complaint remains to be seen.
Okay.
Probably will have a decision from the court based on the briefing schedule early next year.
Sounds good.
So
Thank you. Any other items or business? If not, I call this meeting adjourned. Thank you very much. Glad everyone was able to join us in Pecos Hall. Even though we're not quite there from the tech, it was great to see you all. Have a good weekend.
you.